And good morning, everybody. My clock says 9 o'clock sharp. This is the continuation of the public fact-finding hearing of the Washington State Commission on Judicial Conduct in the matter of Judge Tracy S. Flood of the Bremerton Municipal Court. The commission's case number is 11005-F-204. Again, I'm presiding officer Eric Price, an appellate member of the commission. First, good morning, Ms. Bremner.
Good morning, Your Honor.
Good morning, Ms. Rasnick.
Good morning.
Good morning, Mr. Gross.
Good morning, Your Honor.
And good morning, Judge Flood.
Good morning, Your Honor.
Okay, so this morning we are starting at 9 o'clock as we discussed last night. Here's what I'm anticipating for today, and then I'm going to go around the table and see if that's consistent with what the parties think is going to happen. It's important that we're all on the same page. We are going to start this morning with the testimony of Judge Flood by Ms. Bremner, followed by cross-examination, of course, redirect. And then my expectation is we're going to move into closing arguments at that point. I did receive the document called Declaration Objections and Responses, and I have had a chance to quickly review that. I don't expect to be able to make to resolve the objections that have been made to the declarations prior to closing arguments with the schedule that we have. But I do expect to make those decisions prior to providing the declarations to the panel for their consideration and deliberations. So that's step one. Step two, I want to do some cleanup with respect to exhibits. I do know that I believe that a edited version of the audio that was played yesterday has been provided, and I believe it's been numbered Exhibit 340. My expectation is that edited version, and I say edited because it's edited to reflect exactly what was played for the panel, is to be admitted as an impeachment exhibit. And I want to make sure that's the case before we instruct the clerk to have that admitted in the record as impeachment exhibit. Mr. Gross, is that consistent with what you expect to have happen with 340?
Your Honor, yes. Your Honor, yes, and we move now to admit, and it's Exhibit 340A, which is the edited version of the hearing we heard yesterday.
All right, so Exhibit 340A has been offered as an impeachment exhibit. Ms. Rasnick?
Your Honor, I would first note that there's about 10 minutes of additional audio within the clip that's beyond what was played yesterday. I think the clip is about 47 minutes long, and from about minute 37 or 38 forward, there's audio that has to do with a different hearing, which is not what was played. It goes beyond what was played yesterday. So I would ask that the clip be edited so that that subsequent hearing is not included. And if it's edited down so that the subsequent hearing is not included, I don't have an objection to having it admitted as an impeachment exhibit. Would note for the record that it contains substantial hearsay, but I understand it's being admitted as an impeachment exhibit.
Mr. Gross, what can you tell me about the over-inclusion on the exhibit?
I did not realize that. We can absolutely edit that and submit the correct version.
Okay, so what I'd like to do to alleviate having to make this decision again on the record, Mr. Gross, you will provide a further edited version of Exhibit 340, let's call it 340B. And Ms. Rasnick, once you have satisfied yourself that that's an accurate depiction of what was played for the panel, Exhibit 340B shall be admitted as an impeachment exhibit into the record. Is that acceptable, Mr. Gross?
Yes, thank you.
Ms. Rasnick?
Yes.
Okay, so let's turn back to the schedule for today. That and my recitation of what I expected. I'll turn first to Ms. Rasnick. tell me if that's what you're expecting, and do you have anything further to mention?
Um, First, that is what I was expecting. I would respectfully ask that I have some time after the conclusion of evidence to pull together closing. I'm not going to know until after Judge Flood's examination is correct whether I may have a rebuttal witness. I understand that it would be best to avoid that, but I can't make that decision until I've heard the judge's testimony. If there is a rebuttal witness, it will be very brief. I understand that the desire is to move to closing, but ordinarily one would be afforded at least some time following the closing of all evidence to pull together one's argument. And we can talk about the timing, but I would just like to state now, I would like some time to be able to pull together closing so that I can present an organized presentation to the panel. Um, the only additional matter that I have is we asked the clerk to certify Exhibit 280, which is an additional order that was inadvertently omitted from Exhibit 278, which was certified yesterday and admitted yesterday. So just to be clear, Exhibit 280 is an order that was entered on March 7th in this matter, which was inadvertently omitted from Exhibit 278 that was admitted yesterday. Ms. Baldass has certified Exhibit 280, and I would move to admit Exhibit 280.
Are you also suggesting that is it 278 be withdrawn?
No, as an additional exhibit. 280 would be, it's not an entire
Oh,
new, it's just the one order that's in 280. It's very short. Exhibit 278 is quite lengthy. So rather than confuse the record, we just have submitted the March 7th order as an additional exhibit that is Exhibit 280.
let's take that by itself. Exhibit 280 has been offered. Ms. Bremner or Mr. Gross?
Mr. Gross, Your Honor.
Mr. Gross?
Sorry, can I don't have it in front of me. I just want to look at it. And I apologize. What is the purpose that it's being offered for?
Because it was a record of an order in this proceeding. We admitted all of the orders yesterday under, I think it was the statutory section 544. I don't recall the exact statutory section right now, but this is simply a supplementation of the exhibit previously that was admitted without objection. All of the orders that were entered in this proceeding.
No objection.
It might be helpful for the parties. I realize this is an unusual proceeding and the commission's rules are unique within the legal system. Under the disciplinary rules for judges, should the matter go up on appeal, it's part of the commission's obligation to provide the entire record, including all orders entered in the case, and all orders entered in the case are available to the panel members as well. So just for the information of the parties.
Well, with that information, it has been offered, and without objection, Exhibit 280 shall be admitted. Now, Ms. Rasnick, back to you. When you say some time, are you suggesting 30 minutes, 60 minutes, or 4 days?
I am suggesting maybe an hour, maybe an hour and a half. I'm hoping that it can coincide with our a lunch recess. I don't think it's unreasonable to ask to have a little bit of time to pull together closing.
Okay, so Ms. Bremner, let me turn to you about my proposal for what I view today. What is your response to that?
Well, I mean, I sound like a broken record, but we talked about 1 day for each side. We've been preparing all along for closing. In fact, I usually prepare my closing before I start a trial, just in terms of what I need to cover from the case. So we'll be ready to proceed at the end of the evidence with closing.
Okay, so you view the world consistently with what I represented, which is first the testimony of Judge Flood, and then move to closing, and expecting that to happen today, with, of course, the caveat of a potential request for a rebuttal witness. Is that true?
That is true, Your Honor. Thank you.
Okay. All right. Anything else to raise before we get started with the testimony? Ms. Rasnick?
No, thank you. No,
Ms.
Your Honor.
Bremner?
No, Your Honor. Thank you.
Okay, let us
Yes,
proceed
Your Honor.
then. Oh, Mr. Gross has something.
Apologies. There is something to raise, which is that the judge has a important medical appointment at the VA today at 12:30, an appointment that it took her a very long time to get, and that she didn't want to cancel in the event that she was able to make it, we would object to an extended break to determine whether disciplinary counsel wants to call a rebuttal witness. In any normal trial, you have to make that decision right away. So I think 5 minutes would be fine, but certainly an hour or an hour and a half, we would object to.
Well, no request is being made at this moment, so
May I be heard?
no, actually not. Let's just proceed with the testimony. I am disappointed to hear that there's a conflict with today's scheduling. All right, so let's move forward then. Judge Flood, can you raise your right hand? Do you swear or affirm the testimony you're about to give is true and correct?
I do.
You may proceed, Ms. Bremner.
Thank you, Your Honor. Good morning, Judge Flood. How are you?
Good morning. I'm okay.
Okay. Can you hear me okay?
Yes, I can.
Okay. Can you first state your name and spell your last name for the record?
My name is Tracy Flood. Last name Flood.
And how are you currently employed?
I am the elected judge for the city of Bremerton.
And is that municipal court in Bremerton?
Yes,
When was that election where you were elected judge?
November of 2021.
I'd like to start by asking you to go through for the panel and the presiding judge, your background. Where'd you grow up?
I grew up in Chicago.
Tell me a little bit about your family, parents, etc.
My mom is from Alabama, but I lost her to breast cancer. And my dad is from Tennessee.
What brought you to Washington State?
I graduated high school at 16 and joined the Navy at 17, and my mom had to sign for me to go in.
Okay.
So yeah, the Navy.
It was that in Chicago?
Yes.
So what made you want to join the Navy at that young age?
Couldn't afford to go to college, to help pay for college. And that was one of the options. While I have two older siblings and a younger sibling, and my brother had struggled financially and couldn't finish college because we couldn't afford it. So best way to pay for college with tuition assistance and the GI Bill.
Okay. So tell us, if you could, please, where did you start with the Navy and what did you do?
I went from Chicago MEPS to Orlando, Florida for boot camp.
Mm-hmm.
At the time, boot camp was in Florida, I believe shortly thereafter, before getting out of the Navy, they do all of boot camp in Great Lakes. So the option was Florida or San Diego for boot camp. And I ended up in Florida and went through A school and had when you go into the military, they give you the test and it gives you the options as to your career choices. And I had spent the summer working at McDonald's before that and enjoyed as a family, we cooked a lot. So I chose to be a chef.
Okay. What did you do at McDonald's? What was your job?
I was a cashier.
So can you just, what other duties did you have or work with the Navy before you started college? I'll ask that way.
So in the Navy, I graduated in the top 10 of my class. So I got to work for one of the first Black Rear Admiral in San Diego, because I went from Florida to San Diego for school. And then I got went from San Diego to Texas, and I then served on the honor guard and received accommodation for my work with the honor guard. And we traveled around the southern region, presenting, doing the honor services for our veterans who had passed away, and presenting flags and honoring those families.
What did you do after that?
After Texas, then I got stationed at Bangor Base, Subbase, and that's in Silverdale, Washington area. So that is where then I was my last duty station at active duty, and then I did reserve time after that. And while at Bangor Base on active duty, I went to Olympic College at night, transferred over to a day student, and got involved with student government at Olympic College. Graduated from Olympic College, and I was the graduation speaker. And then I transferred to the University of Washington by ferry. So my commute via ferry started.
Okay. And what year did you graduate from VU?
Oh my goodness.
That's okay.
So it was 94. Oh, I'm sorry. The calculation of time. I transferred over to the UW in 92. But so I have 2 BA degrees from the University of Washington. So that's why the time's mixed up, because I was so close to the credits, that my transfer credits and the credits that I had were enough to, within a few credits of, instead you could minor, you could have a minor and a major. So, but it was more advantageous to have a BA in political science and a BA in sociology. So I extended a few months. Yeah.
Okay. And then presumably you went to law school.
Yeah.
You're a judge. Where did you go to law school?
I went to Seattle University. At the time when I applied, it was still the University of Puget Sound. So I was the last graduating class on the Tacoma campus.
And why did you go to law school? I've asked myself that a few times. Go ahead.
It was a way to get to my dream. My dream was to be a lawyer and ultimately become a judge.
Incidentally, did you appear on the cover of the Seattle University Law School magazine, Seattle Lawyer?
Yes.
And when was that?
I was cover, first time I was a part of the cover story for Seattle University Law was when I was at the U.S. Department of Labor. I was working at the U.S. Department of Labor as a specialized examiner, and they did a photo shoot and everything for the office I was working in. And that's a quasi-judicial position with employees that had been injured at Department of Energy facilities.
Have you appeared on the cover more than once?
Yes.
And when did you most recently appear on the cover of the Seattle University Law School's magazine?
I was a part of the feature story last fall. Yeah.
On the cover?
It was a cover story. So this cover story was like a feature for multiple the stories and for backgrounds of attorneys and judges and their unique stories and backgrounds. Yeah.
And what made yours unique?
While I was employed at the U.S. Department of Labor, my brother had a massive stroke. And this is my older brother.
Mm-hmm.
He and my brother was a chef at had graduated from Cordon Bleu and had been a prestigious chef at one of the top restaurants in Chicago.
Mm-hmm.
But he had a heart condition that went undetected. So he had a stroke and he is no longer able to work.
Mm-hmm.
So while I was at the U.S. Department of Labor, the director allowed for me to be able to commute back and forth to Chicago to help care for my brother. And I ended up having to become his guardian. And he I had to move him out here in a nursing home. So I went back to school and got my LLM in elder law. My experience with the court system in the circuit court in Chicago and seeing all the families and the difficulties in navigating guardianships for me as an attorney was difficult.
Mm-hmm.
And seeing these families was, and my experience, I wanted to help in a different area. So I went back and got my LLM.
And what did you do after that, after you obtained your LLM?
I started doing elder law, and it was right at the heart of COVID. COVID hit, and I really considered it a blessing that I had actually got my LLM. COVID hit,
Mm-hmm.
and I was actually able to help so many people in nursing homes
Mm-hmm.
that with their planning for end of life, getting power of attorneys and things to their family members. Because if we remember at the height of COVID,
Mm-hmm.
they were not letting anyone in to nursing homes to visit
Right.
any of the family members. But because of my specialty, I was allowed in. So I traveled the Highway 16 and I-5 corridor on a regular basis, providing services to individuals in nursing homes. And the connection was through veterans, Retzel, the VA hospital and a facility in Port Orchard. They would call me often. And because I had moved my brother out here to a nursing home. And Life Care Center, actually where my brother was one of the first nursing centers that actually had the COVID outbreak. So it was a very difficult time.
Do you have a family besides your brother out here?
Yes.
Tell us about your family, please.
So presently in Washington is my husband, and he's an engineer. He was one of the top engineers on the Seattle Tunnel project.
Okay.
And then, so very proud. He's also the president of the NAACP for our local chapter. And my daughter isn't in this state, but still home. She's at the University of Illinois Champaign-Urbana working on her. She'll be defending her dissertation next year. And she is a graduate of Fisk University, one of the top 10 HBCUs. And my bonus son he came to be with us during his high school years, and he graduated from Central Kitsap. During my younger sister is actually a graduate of Bremerton High School. When my mother passed, my younger sister came to live with me. So she graduated from Bremerton High School.
So why do you say bonus son?
Because it's by marriage.
Because he's what?
By marriage.
By marriage.
Not by birth. And then I have 2 bonus daughters.
Okay.
That are both married and outside of the state. One in Germany and one in North Carolina.
Okay. Have you won any awards as a lawyer and or as a judge?
I've been honored by I'm a graduate of the Washington State Leadership Institute. It originated under the Washington Bar Association, but it's then transferred over to the University of Washington, and it's now the Washington Leadership WLI. I was in the inaugural class of WLI, and I received the first 2 Thumbs Up award. And that was created by them for being the first graduate of WLI to be elected to the Board of Governors. And so then I have received the Washington State African American Achievement Awards. I've received awards from our local YWCA Women of Achievement Award. I've been recognized by Washington Women Lawyers and received one of their presidential awards. I received awards from the Longmeadow Bar Association Social Justice Award, and I have accommodations and awards from my time in the Navy as well. And then I was recognized by the Department of Labor with my work there through our CFC campaign and by our region. Navy's kind of the federal government is similar to military and when they give awards, so for the regional area. And there's some more there. For my service on the Kitsap Community Resources Board, I received the plaque from the board after serving my term there. And then some other recognitions for other board services that I've done. Thank yous and certificates.
How old are you, by the way?
I'm 55.
And how old were you when you graduated from college?
Which part?
I'll go back. Just when you had to have your mom sign for you to go in the Navy, were you 16 or 17?
I was 17.
17, okay. Now you ran for judge. First you pro tem'd at the court there, is that right? In Bremerton?
No. In Kitsap County.
Oh, in
yes,
Kitsap
but
County.
Not the city of Bremerton.
Can you tell us about that, please, your pro temping experience before you ran for judge?
So I was a pro tem for the Office of Administrative Hearings during child support hearings. I was a pro tem for the city of Port Orchard. At the time, my office was across the street. So Port Orchard is a part-time municipal court. So Bremerton is the only full-time municipal court in Kitsap County. So the judge in Port Orchard lived on Bainbridge Island. So there was times when there was someone in custody that needed to be arraigned, and I would fill in because my office was right across the street for her. So that happened maybe, once a week. And then for the city of I'm sorry, excuse me, the city of Edmonds.
Edmonds, okay.
Edmonds Municipal, I pro tem for them for quite a while, and that was consistent to my time working in downtown Seattle. I would take the Kingston Ferry up, pro tem for them for half a day or a day, and then if it was half a day, I would go to my office in Seattle afterwards. My time with Kitsap was when Judge Page mentored me, and we went through a time with her, sitting down, going over things with me, and then me observing court there, I think on a handful of occasions, and then being regularly scheduled with them to pro tem. And I was one of the first pro tems trained on their new electronic systems that they have in place now.
Now what year did you run for judge again for Bremerton Municipal?
I ran in November. My election was November of 2021, so it was the 2021 calendar year.
And why did you run for judge?
For me, this was my actual second time running for judge. I first ran for a district court position that had been opened. That was a grassroots campaign and really learning about politics.
Okay.
And
we don't want to talk about politics right now. Sure.
So the reason I ran was because it was an open seat and I wanted to make change. My experience as a public defender, being a part of the community, living and working in the community, volunteering in the community, being service before self. And I had the opportunity to meet Justice Sotomayor when I was at the U.S. Department of Labor. And I sat next to her in lunch, and she said that she talked about service and that the job of a judge is really serving. You're really serving the community. And that a lot of service work is not recognized as service. And that resonated with me. So when it came time and the announcement of the retirement, I said, it's time.
And that was the retirement of Judge Doctor, is that right?
Yes.
Did you talked about a prior grassroots campaign. What kind of a campaign was this one for municipal court?
I took everything I learned in that first campaign and applied it to this one. So I called the first one grassroots because it was me and some of my good friends up late at night sending out letters, and I didn't have a campaign manager or anything. And this time I had a campaign manager and a lot of support from community. I did, of course, get the position. So it was a lot more supported and rooted in connections, relationships, my work in community, and my commitment to community.
When you first, well, you spoke about wanting to institute some change. As you became the judge in Bremerton Municipal Court, what kind of changes did you have in mind?
So I talked a lot about it on my campaign trail, that I believe that our community, the Bremerton community, the court being the only full-time court, needed a community court, therapeutic court program. And the timing was, it seemed very right with the legislators putting money into these programs, and actually the county doing the 1/10 of 1% tax to focus on mental health and substance abuse. And it became even more relevant and pervasive when we see the homelessness, the crises related to the mental health and trauma, and many of the abuses as to the effect of meth and other drugs that we see.
Was there a therapeutic court at the Muni Court before you became the new judge?
No.
Okay. Who started therapeutic court at Bremerton Muni?
I did.
Okay. And is that what you call community court?
Yes.
Okay. What is community court? If you could tell the panel and the presiding judge, what is community court? Go ahead at Bremerton Muni.
So for the city of Bremerton our program is, I believe, unique to meet the needs of the city of Bremerton. Community court programs are commonly known as drug court programs, but they have delved into more than just the substance abuse.
Right.
And in our court, we deal with a lot of dual diagnosis. It doesn't have to be a dual diagnosis, but the majority are dual diagnosis. And you're dealing with the traumas that come with that. So we have the community court aspect of it, because it's unique, because a part of the therapeutic court program that makes it a community court is we have 3 resource fairs a year, in which we go into community, which is our community center that's about a block and a half away from the courthouse, and quarterly have resource fairs. We bring in community partners, resources from the state, federal, local, and bring everything into one place. And our post-conviction defendants who are on monitoring also participate in that, and our services support specialists are there to meet with their clients, connect them with resources. And it's community wide. So the Bremerton is a military town.
Right.
So you have a lot of people that work for the government, a lot of people that come through Bremerton that may not reside in Bremerton. So we're serving more than just the city of Bremerton. We're serving our community as a whole, those that impact the city of Bremerton.
And how often does that court convene?
So weekly, we have our therapeutic court, community court calendar. That's usually on Tuesdays. And there's been a couple of occasions where it's moved, but consistently on Tuesday mornings. And a part of the community court program is we do staffings. And in the staffings, I hear from our treatment providers as to how things are going. So they're partnered with us. And then I hear from the participants. So it's not a typical hearing. It's not where I really coming on the record and calling the calendar. We have little remote control microphones that I pass around, and they pass around to each other, and kind of report in on how they're doing, check in on their progress, and things that they need support with. And then they are connecting with the probation and services support for any needs that they may have. This program was established by, I wrote 3 grants to get the funding to be able to create the program.
So this would be a big change from court when the previous judge was there, it sounds like, at least the therapeutic court, because it didn't exist. Okay.
Yes.
When you came in as the new judge after your election, how many full-time clerks worked there at the courthouse, your courthouse, full-time?
So there was
Approximate is
5.
fine.
I'm sorry, 5.
5, okay. And have you you've talked about the therapeutic court and you had people in there. Did you have clerks in there when you ran the court? Any admin staff?
So
I'm gonna withdraw that question, actually. Let's start with how big the courthouse is. I know we've had some descriptions of it. Is it pretty small, that courthouse in Bremerton?
No, I guess it's a matter of opinion.
Okay.
We do have 2 courtrooms. We're unique, and we are not in City Hall. A lot of courts, Edmonds,
Right.
The city of Renton, their court, Des Moines, a lot of those courts share buildings with city departments. Our court is unique in that we are about a block and a half or a block, city blocks over from the Norm Dix building, which is our city center. And it's actually an old bank building that we're in. And so the makeup of the building is when you come in to the building, security, and then to the left, we have a room that's been known as the Zoom room that's being transformed into having food for our community and clothing. And then next to that is the public defender's office. And then that's on the left when you're walking in. To your right when you're walking in is a lobby area. And bathrooms, and then a door that is for staff that leads to the staff area. But then the window areas for the clerk's office is just past that waiting area to the right. And so it's kind of like I think the best way to describe it is a fishbowl.
Fishbowl?
Type. Yeah,
Okay.
it's kind of like a large open area. There's 4 windows, areas that you can actually address the public.
I take a moment here and close my windows. There's a bunch of noise. Can anybody hear that, or is it just me?
I have not heard anything from your end, Ms. Bremner, but do what you need to do to be
I'm
comfortable.
having a little trouble. Somebody's out with a leaf blower, I think. Thank you. I'm back. Please continue, Your Honor. Judge Floyd, please continue.
So so that's the first floor, and then on the inside of the clerk's office, which I am referring to as the fishbowl, again, the 4 windows where they would be able to address the public. But there's 3 computer spots for being able to take receipts and give paperwork and sign paperwork. So 3 window areas. And then there's desk behind those areas. Like 3 in a row, and then back by the back door is another desk area. So there's 4 desk areas outside of the 3 window areas with computers. And then there's 2 offices in there. And they're against the furthest wall, facing on the Norm Dick side of everything. We have our own parking lot. And then upstairs is on when you come up the stairs, we also have an elevator. You come up the stairs, to your right, we have 2 mini conference rooms that allows for attorneys to meet with their clients. And one has been converted to our community court office areas for our participants to be able to utilize that space when they need to meet with any of their counselors, or to have privacy, because we have made arrangements for there to be evaluations done at the courthouse in that community court designated little conference area has been designated to do that. Next to those 2 conference spaces is our probation department. Starts with our one services support specialist who's dedicated to probation. Next to that office is the prosecutor's office. Just down the hall from there is our jury room. And on that side also is our courtroom 2. And in between courtroom, on the other side of courtroom 2 is we have a library, law library. And then courtroom 1 is the larger of the courtrooms. And my main courtroom, a kitchen area on the outside of courtroom 1. Next to the kitchen area is 2 restrooms, and then another restroom for defendants when the jail does transports. And then on this side of courtroom 1 is my chambers and our community court specialists, service support specialists offices across from there. That had traditionally been the courtroom clerk's office when there was just one courtroom clerk.
And then your
So-
chambers?
Then my chambers, and my chambers is right by the stairs that lead down to a 2 storage rooms.
Mhm.
So our supply storage room, and then what used to be a file room, it still has some files in it, but it's used as our, I want to say mail room,
Okay.
kind of. And then kind of a hallway area. And then another utility box room.
Okay.
And then the back exit doors, there's a hallway there. So when you come down the back stairs, there's 2 doors, one door leading into the clerk's office, and then one door that would lead you into the lobby area. And that's right on the same side as the stairs. And then you would go to another hallway to get to the back doors.
Okay. Let's turn to how you act and how you talk at work and on the bench. I mean, if we were to come in and see you, I mean, what kind of tone do you use? And you talk relatively slowly and carefully. Is that the way you talk in court?
Yes.
Okay. And then what about the tone you're using here? Is it similar to the way that you talk in court?
Yes.
Okay. Any different? I mean, in tone or volume from how you're talking here today?
The only time my voice is raised is when the parties have said they can't hear me, and usually that's like on Zoom. I'll try to adjust the volume, or I'll try to get closer to the speaker,
Right.
or I'll like kind of, because I have sometimes a lot of hoarseness, and I'll try to increase my volume as best I can, and that'll take a couple of tries. But other than that, I'm pretty consistent.
Okay. Have you ever treated any litigant, defendant, staff member, or any member of the public with discourtesy during your time as a judge?
I don't believe so.
You what? I'm sorry.
I said, I don't believe so.
Okay. And have you ever yelled at anybody, either from the bench or around the courthouse?
No.
Have you ever engaged in any kind of speech against anybody, public, staff, defendants, lawyers, that would be considered discriminatory based on someone's race or gender or sexual identity, immigration status, or anything else?
No.
Okay. Would you ever do that?
No.
With respect to what we have heard in this case, when did you first learn that there was a CJC investigation or complaint? I'm not asking exactly, but generally.
One of the defense attorneys yelled at me in court and said that he had filed a CJC complaint against me.
Okay. Who was that? Do you remember?
Eric McDonald.
Who was it?
Eric McDonald.
Okay. And who is Eric McDonald?
He was a public defense attorney and family law attorney.
And did you ever learn what the nature of that complaint was from him?
Other than what he yelled in court, no.
So he yelled, I filed a CHAC complaint against you. And he did that in front of everyone in the courtroom.
Yes.
How did you feel about that?
I was a bit shocked,
Why
but
is that?
I kept going with the calendar.
And why were you shocked, Your Honor?
At the worst that he would say, the way that he spoke, the anger that he displayed.
You said you just kept going on your calendar. Did you chastise him in any way? Try to shut him down? Complain after the fact that that was completely a wrong thing to do? Anything like that?
I did my best to redirect the focus back to the defense.
And did that work?
Eventually, yes.
But not right away.
No.
Now we've heard from Jennifer Johnson. Did you work with her?
Yes.
And was she someone that you basically inherited from the past administration of Judge Doctor? Or did she come to work with you per your request?
So Jennifer Johnson came through. Initially, I didn't know what she came through, but Ms. Kinlow indicated to me after I reached out about courts helping courts and some support that she would be coming with with another court administrator.
And that was Jennifer?
That's who, yes, she came with, yes.
How did you get along with Jennifer in the beginning? I'm assuming you hired her, right?
Yes.
How did you get along with her at first?
There was just learning about her. She initially it was a relief that I have two court administrators here to help. So again, it was a relief. And then I believe it was Amber who told me she appreciated having the support and that the feedback from the then staff was that they were happy that we could get the support on the admin side of things. And
oh, go ahead. I don't want to cut you off. Go ahead.
No, so there wasn't anything other than this person has worked in the field and they have the information that I need to have my court operate. Yeah, it wasn't.
You heard Judge Leon testify. Did you know anything about Jennifer Johnson thinking about suing Des Moines or the judge and having a yelling match with that judge and pushing back on that judge and then leaving early without giving adequate notice?
My only information was directly from Jennifer that Judge Leon had given her permission, support in coming to help, and that say, she was for like a week there going back and forth between the two courts.
Right.
She's explained that she needed to do that. And I, again, was appreciative that Judge Leon let her come over. But I didn't get to talk to Judge Leon before I hired Jennifer, because Jennifer told me Judge Leon wasn't available, and I believe she may have had a death in the family at the time and was not available.
Jennifer said the judge wasn't even available to talk to you?
Yeah.
If you'd known those things about Jennifer, would you have hired her?
It would have given me pause, and I don't know that I would have.
Okay. Now, there was you heard her testimony. Did you have any, did you ever treat Jennifer in an inappropriate, condescending, or rude manner?
Not in my opinion.
Not in your way?
Not in my opinion.
Okay. And did you experience what we've heard as a term, pushback from Jennifer at different times?
Yes.
Can you tell us about the pushback in Jennifer in those times?
Many of times throughout my tenure here, as long as I'm saying yes and agreeing, things are perfect.
Mm-hmm.
As soon as I say no, I disagree, I'm then told that I can't do things. That's not how it's done. Straight out blanket. You can't do that. So we would, in the beginning, it was coming in and giving me a lot of information. These are the things that are going on. This is what I found. Suggestions to take to city council. And we took a lot of things to city council. We meeting with the director of finance, and giving me the information that I needed to make the request, because the city of Bremerton, while she was the court administrator, they would still come back and ask, has the judge approved, and require my input.
Right.
Even though, again, she's whoever was in the and who's ever in that court administrator's position, they still would ask for my approval. So the information had to be brought to me for me to be able to then approve what was going on. That happened many a times with like our computers, laptops. A lot of the computer systems were old and had not been replaced for years. We met about the getting everything together that we needed to give to the city for the remote clerks that continued on to support the court. And we changed them over to part-time temporary employees. So we, all of that information would come forth, and we would she had to do PAFs, and I have to sign off on those. So there came a time where the information stopped, where we would have a meeting and something would be discussed, but then I wouldn't hear anything. So, of course, if you don't hear anything and you're trying to get information, you begin to ask questions.
Mhm.
And that became you're questioning my abilities. You're questioning if I can do my job. You're making me feel like I can't do my job.
What are you saying? She's making you feel like you can't do your job, or
No,
she's saying,
that's her response. That's
gotcha.
their responses.
Please continue.
So again, yes and no questions, things perfect. Questions, then I'm demeaning or picking at things. That became the responses.
You said picking on you and demeaning, is that right?
So that was their response, that I was picking on them.
Gotcha. Okay. And were you?
No. So the issues of questioning wasn't one of, I shouldn't ask questions. That was the sense and the impression I was given, is that you're not allowed to ask questions. We just need to do what we want to do, and you're just to sit and not ask any questions, just to do what we tell you to do.
And when they're saying, do what we want you to do, don't ask any questions, who besides Jennifer was doing that and saying that?
The first time it happened was with Don Williams.
Right.
That's not how things are done here.
Mm-hmm.
That's not the way we do it. And I understand that historically things may have been done a particular way.
Mm-hmm.
But when you ask the question, why have you historically done it this way, so that I can understand why it's being done this way? And the response is no answer.
Mm-hmm.
It's the sense of just because, okay? So my thoughts and practices is, okay, let's try it this way. Let's do it a different way. It doesn't hurt anything if we try it a different way. If it doesn't work, we'll try it a different way. But the system, the criminal justice system is broken. I didn't break it. The criminal justice system has been inherently broken for a while. We have a crisis with our public defenders all over.
Mhm.
We have a crisis with judges' salaries in the state of Washington catching up with where they should be. We have a crisis in the revolving door with people who have mental health issues, and Western State Hospital being able to
Right.
serve the community the way that it needs to be served. We have a crisis as to mental health counselors, substance abuse counselors, and suggesting and wanting to do court differently doesn't mean that I'm some liberal judge wanting to let everybody out of jail. And that's some of the hate mail that I've received. We see a lot of the same people. Criminal trespass,
Mhm.
theft, stole a sandwich, went in a Safeway, sat in Safeway, eating a sandwich. Because of COVID, there was an encampment just a block over from the courthouse. The effects of that and that being cleared out increase the number of individuals then that we were seeing. But they're the same individuals. So when the opportunity came to, and knowing that the grant funds was available, I wrote again the grants to create the community court to be able to address it. And the 0.1% through the county receiving the support to be able to do that, creating these additional position with the court. And also knowing that, again, I said our computers outdated, getting an AV media grant. So we experienced a summer, a little bit over about approximately 6 months, where we were having construction at the courthouse on our AV media system. And I'm hearing now that I'm being blamed because some of the recordings, a couple of recordings were lost on the system. IT issues happen almost on a daily basis in our court. The upgrades that were done, I believe, are a great improvement.
Mhm.
We had a malfunctioning of a microphone. And that one handheld microphone has still not been fixed because it's a couple of $1,000s to get it replaced. And so a lot of money was spent to bring our AV media systems up from where they were when I arrived, the microphones in the courtrooms were not working. We were using a OWL, OWL. So, in
Well, I don't even know what that is.
it's it's a standalone device
Okay.
that does a 360, like a camera and a microphone.
Okay.
So that's what we had. And then for a while, systems were every day. That was a challenge too, having to be plugged in and unplugged, plugged in and unplugged. Without the communication and information, there's a lot of things that happen that I have no knowledge. And then when the information does eventually get to me, if it does, it's usually so far gone, corrective actions to try to fix things were not accepted as that. It became the judge ordered or the judge said. When there was information being relayed. And many a times, my suggestions would not be done or carried out.
Mhm. It looks like you're still answering, you're still thinking. Is that right, Your Honor?
You can ask another question.
Ms. Bremner, be thinking about a breaking point. We are going to need to take our mid-morning break fairly soon, but I want to make sure you're at a place in which that makes sense.
Well, actually, this is fine right now, Your Honor, because I'd be on to my next question, if
Okay.
that works for the court.
Yeah, so the time is now 10:18. Let's take a full 15-minute break. Well, it's now 10:19. Let's go 16 minutes. So we'll come back at 10:40. And Mr. Gross, I think I'm going to ask that you have your client try to make other arrangements for this appointment. I do not believe, I'm very pessimistic at this point. All right, I have 10:35 by my clock. Waiting for a few more folks to rejoin with their cameras. Commissioner Schley has his camera on. We can get started. when Commissioner Briggs turn to her seat. All right, are we ready to resume, Ms. Bremner?
Yes, Your Honor.
Ms. Rasnick?
Yes, sorry.
All right, you may proceed, Ms. Bremner.
Thank you, Your Honor. When we first, Judge Flood, when we first started this hearing, there was an allegation that you had taken on a court calendar that directly conflicted with the commencement of these proceedings. Was that true? At 8:30, the first day of this hearing, were you?
Sorry.
Is that true? Did you take on a calendar, thumbing your nose at this proceeding in this panel?
No.
Okay. What happened that morning?
We were in a drug court, the state drug court training last week, Wednesday, Thursday, Friday. And that training was our community court services court specialist. And we had been waiting. We had community court last Tuesday, and the update was that a bed date would be coming through at any time for one of our participants who had been in custody for a number of days. That information for the bed date was that the bed date was Wednesday of this week. And so we were really excited that information was emailed out to everyone, but the details of who was picking up, who was the in-between transport, the need to get him to a transit center between his actual bed date, getting him back on insurance, all of those things that was not readily available, and the need to hear his matter at 8 o'clock was necessary. But our clerk who does the morning calendar was already gone. So the request would need to be made that Monday morning, and that paperwork would need to be done that Monday morning. Being that our proceedings were not set to start until 8:30, I asked my commissioner to come on at 8:30 or a little bit before 8:30 so that I could transition to come over after we were able to handle Mr. Sampson, who again is one of our participants. And Mr. Sampson's case is very complex. He has over 10 cases that are, and I may or may not be exact, but, and it may be more than 10, but approximately that many cases. So it's a very complex case, and I wanted to make sure that this participant got the orders so that this bed date and it's a long-term facility. They don't come open often. He has a dual diagnosis, and it's for a 3-month treatment program. So to secure that bed date and that in this time, and making sure the jail got what they needed, and the orders being very concise with the details of him needing prescriptions and all of that stuff that goes with arranging long-term sentences and I shouldn't say sentences, long-term treatment obligations for inpatient treatment was necessary. And I wanted to take the time and care to make sure that he got those orders. And the next day, it couldn't be done on Tuesday because that would have been too late. And the city had the network scheduled for an outage on Tuesday, and we had all kinds of IT issues Tuesday morning. So it's a bit disheartening that is being presented to this committee, that me as a judge trying to ensure due process, trying to ensure that a participant, a defendant who has been through this court multiple times can finally get the treatment that he needed. And I was just trying to take care of that. Our calendar is a calendar that it's every morning, it's a video in custody calendar, Monday through Friday. We have a limited amount of time to deal with anywhere from 10 to 20 sometimes defendants in that hour. On Tuesdays and Thursdays, we start 15 minutes early. It's disheartening that I'm being criticized for wanting to make sure that the orders read correctly, that they, of what I'm saying to take place, especially when it's something specific as to a specific release time for a defendant to be released to a particular agency or transport company or the real team to get to their inpatient treatment or outpatient, the specifics and the details of making sure that they get their medications, their prescriptions, because if they don't, and the orders don't read those specific things, they can get to the facility, ABHS, any one of the facilities, and the facilities will say, we can't take them because they don't have their medications. We can't give them a prescription. So there's so many moving parts that take place. And I wanted to make sure that after him being in jail for so many days, waiting for this specific treatment for both mental health and substance, and it being a 90-day program, would not have any issues.
So at 8:30, when our hearing was starting, did you have a pro tem schedule to cover for you so that you could attend this hearing?
Yes, I was done off the record. I believe the time that I looked at was 8:27.
Okay. Now,
yes,
somebody from the court got a hold of Ms. Rasnick and said that you were presiding over a whole different calendar while you were supposed to be before this body and this judge on that morning. Who did that? Do you know?
I do not.
Okay. I mean, obviously somebody was watching this hearing that works for you or works for the court and went in and gave this false information to the CJC prosecution.
I'm going to object to counsel testifying. There's no foundation for this.
Sustained.
How would anyone other than those connected with the court be able to make that representation if they made it to counsel?
I'm going to object. This calls for speculation.
Overruled.
I don't think it does, Your Honor. It's a small court. And
Ms. Bremner, I've overruled the objection. If I give me a moment to rule before you respond.
sure.
If I want you to respond, I'll ask for it. Thank you.
Thank you. Go ahead, Judge Flood.
It's my impression that, and from what's happened in these proceedings so far, that the information would have had to come from either the court administrator who said that I canceled the pro tems that she had scheduled, or the prosecutor who was on the hearing with me.
Objection.
I do not
lack
know.
of foundation.
I do not.
Objection. Lack of foundation.
sustained.
I'd like to respond, Your Honor. Well, I'll move on. Do you have an impression of who had the ability to observe what you were doing that morning at court?
There were a couple of people who were able to observe it. Our hearings are open hearings. They're recorded. They're public. Anyone can log in. I think the impression that I have is that there's a lot of pushback to the care, the time, the patience that I have with defendants and participants.
Okay.
That I should just rush through things. And that's the impression that I'm giving, that in essence, she takes too much time with the defendants. So I take the time to hear from them. I think that that's important. I want them to know that I see them, that they matter. And that same, which I found interesting, because there was one time a comment was that you talk to me like you're talking to a defendant. And my opinion is, and my feeling is, that I take time and care with everyone. So the communications that I have with the pro tems as to availability and needs, anytime where there's a possibility of there being some change, I let them know to hold their dates directly, and for them that I will check in with them if there's any changes, because there is always a lot of changes. And there was a mix-up, in my opinion, in regards to what was needed and what was being requested as to information. There had been no arrangements for me to have a pro tem during my last week's training, other than Friday. I went and adjusted my original registration to attend Wednesday, Thursday, and Friday, because I'm a part of the District and Municipal Court Associations, Judges Association's Therapeutic Court Committee. We made, the chairs made arrangements for us to meet at the conference on site, and they were encouraging if you could clear your schedules to try to be at the full conference. We didn't have any trials on Thursday. Commissioner does the Wednesday afternoon calendars. So with that in mind, being a single court judge bench, any opportunities for me to be able to be around other judges, to learn and get information from other judges, I try to take advantage of. And so that led me to be there Wednesday, Thursday, and Friday. And the reference to trainings, was mixed up with this week saying trainings versus last week in trainings, in my opinion.
All right. Do you know a gentleman named Davies?
Yes.
Now, our judge here had indicated asking for public comment with respect to our request to seal your medical records and the accompanying affidavits or declarations. And there was one objection. It was from Mr. Davies. Is he connected to the court in any way, or do you know him?
Yes,
Tell us about that, please.
Mr. Davies was and is good friends with all of Judge Doctor's staff that was on staff when I joined the court. He was the,
Objection, personal knowledge, lack of foundation.
I'm going to allow questioning to this area, but Ms. Bremner, set some foundation if you would.
What do you know about his background vis-a-vis his work or association with those that work for Judge Doctor?
I was a public defender at one point in time during my career.
Okay.
And Mr. Davies had been a prosecutor with the county and had stopped being a prosecutor and had took on pro tem work around the county. So I actually had appeared in front of him while he was pro temping. And he was one of Judge Doctor's pro temps when I started.
Did he ever want a pro tem for you?
Yes,
And what happened with that?
he did for a while.
And did that change?
Yes.
Why?
My understanding and impression was that he didn't believe I had done anything wrong, but he sided with his friends.
And when you say friends, we're talking about the staff that had been there under the other judge, right?
Yes,
Okay. And some of those people came into your administration, right?
yes,
Okay. Are those people that you've had trouble with along the lines we've been talking about in this whole hearing?
yes.
Okay, let's turn to some of that right now. But we talked a little bit about Jennifer Johnson. Did you ever have any kind of yelling matches with her, like Judge Leon described she had with her?
No,
Okay. And there were some specific things she testified about. Can you comment on what she had to say and whether or not what she had to say was true from what you heard?
Objection, the witness cannot comment on another witness's truthfulness.
I'm not asking that, Your Honor. I'm asking her whether or not she agrees with what was said in terms of what happened.
Sounds like asking for the truthfulness of some witness's testimony. It does sound like impermissible to me, Ms. Bremner. Do you have a further argument for how that's admissible?
I'm trying to expedite, Your Honor, because there's a lot to go through now in terms of false allegations. So I was trying to go generally in terms of what was said and what the judge's response is, but we can break it down, I guess. But I don't, it's not asking, you can't ask somebody to comment on someone else's credibility. I agree with that, but that's not what I'm asking her to do. I'm asking her to say what she heard and whether or not those things happened.
The question I heard was, did you hear the testimony and was it true?
Okay, well, I can ask it a different way, Your
Okay,
Honor.
I'll ask you this where I'll sustain the objection.
All right, thank you. The things that she talked about in criticizing you, did those things happen?
it is my opinion that the things that are being said by everyone is their personal impression of me because they didn't like me and they do not like me. Some people came in, I believe, with motivations other than to help.
Objection, lack of foundation.
Overruled.
And there was never enough time that passed between fires to allow for there to be an opportunity to truly address any issues. When Don left, I was not present for her final 2 weeks, as it was the month of July. My, excuse me.
Do you have some water there? I got it. Okay.
During my anniversary. So we had plans to travel to Atlantic City. And in the month of November is also an annual CLE conference that I attend. So I'm not sure what was going on as far as testimony about what was happening with Dawn her last 2 weeks. She sent out what I believe to be a nice final note to me, an email with a lot of details. And she also had prepared some checklists. But she also had told me she was leaving about a month prior to her filing her actual resignation letter. And she had interviewed for the position. She wasn't sure if she was going to get the position, but she wanted to give me that courtesy. When she left, she again left me a card and a gift. So I was a bit taken aback by all of these things being said. After she left, we communicated by phone, by text. She continued, there was some, especially on the 1/10 of 1% grant, because she had actually set up the login information, and I needed to get that from her. So it again, this is a bit disheartening when you then hear that this person, or I caused this person to be in tears. My belief is that what I was told is that the job with AOC was new.
I'm going to object. Hearsay, lack of foundation.
Overruled. Doesn't go to the truth.
That it was new. It was a totally new department being established around the Blake decision. It would allow for there to be remote work and more time with family. That's truly what I believe, because that's what I was told. The issues that arose in September took me into an HR meeting where I contacted HR for assistance. And the response was there wasn't any funding. There was pushback, in my opinion, from HR. And the HR department comes up under the city attorney. So there isn't an independent director of HR for the city of Bremerton. There's only an HR manager. And that pushback came early on when I inquired about applications being redacted, all of the information being redacted in applications, and if there was a policy that the city had. And the reasoning why that would be where you wouldn't even see the institutions where they went to school. I was immediately told it was the mayor's policy, and they're there to implement the mayor's policy. And that's not how things are done. So then I reached out to one of my judge friends who connected me with Trish Kimlo. And that was around the first part of September, if I remember correctly, maybe around the second week of September. And the immediate need was trying to address that I had a assistant court administrator at the time who had just become the assistant court administrator. The previous judge created the position in December of 2021. So prior to December of 2021, there was 2 legal technician 1s, 1 legal technician 2, and 2 senior legal technicians. So the role of assistant court administrator was just as new as I was, starting in January of 2022. And it was not to my knowledge of the existence of the court helping courts. I believe Ms. Morrell from Seattle Municipal Court was the chair at the time. And I had spoken with her over the phone too, D. And again, she's with the city of Seattle. So again, I can only speak to my beliefs. I am in no way trying to say that a person can't have particular feelings, because I, unfortunately, no human being can control how another person is feeling. But you can't get to know a person in 30 days in a working relationship that is new and expect that everything is going to be perfect. No one is perfect. And no world is any job perfect. We deal with the public every day. Needs are different from everyone who walks through that door. There's not a one size fits all, but there's this sense of that's how everyone should be treated. Credit for time served, take the plea.
Mhm.
The particular issue of saying to Miss, my court clerk, take the cash. It's okay to take the cash. Taking the cash from a non-English speaking defendant isn't disrupting relationships. It's providing customer service. It isn't saying in every case, you're going to do this. This defendant was standing in front of her with cash, barely understanding, not really understanding what she was trying to explain to him. There was more time spent on trying to explain to him to go and contact this potential credit collection agency than it would have just to take the cash and to receive.
Your Honor, I'm gonna object at this point to the continuation of the narrative testimony. I don't know what the question was or if this is responsive to it, but I'm gonna object to respondent continuing in this manner.
Well, I can ask another question, Your Honor.
Well, Ms. Remmer, let me suggest this. I'm trying to be respectful, obviously, of both the style of your examination and the style of the answering, as well as the importance to your client of these answers.
Mhm.
However, Ms. Rasnick has a good point. This is not the way this generally works. I too have lost sight of what the question was. So if you can be a little more directive with your questioning, that would be appreciative. Thank you.
Sure, Your Honor, but I think that she's going through, well, I'll ask another question, but I think it's very important that she be allowed to explain in her own words, and sometimes it is narrative because of what she's been through.
That's exactly, Ms. Bremner, that's exactly what I just said. But in fairness to the process, let's be a little more directive. Thank
I
you.
will. Thank you, Your Honor. So when you made the statement, take the plea, do the deal, I mean, that's the way things are done, was it your sense that before you came along, that basically that's the way things were being handled?
Yes.
Okay. We heard from the city attorney, Mr. Hersey. I guess he's an assistant city attorney,
City prosecutor.
And he sounds like he struck a jury. Is that something that should have been doing, or would that be your job as a judge? to strike a jury on a case that's set for trial.
I'm going to object. This question assumes facts not in evidence.
Um, let's backtrack to him. First of all, did he ever?
So I was waiting for the judge to rule on her objection. Should I talk?
I overruled the objection.
I'm sorry, I didn't hear you, Your Honor. I didn't want to start talking and I didn't hear you.
Go ahead.
Okay. So the roles of what a city prosecutor's job is and what a judge job and what the court operations do is pretty clear. I'll use the court is a neutral. We're Switzerland is
Okay.
a good way to put it. And we deal with the dealing with setting up the juries. And for our court, we are contracted with the county.
Mhm.
And the county sends out all of they do all of the juror summons. It's in the court's budget for this contract that we have with Kitsap County. So there's a juror department. I don't know if it's a department of coordinator where they want to know by noon the day before as the last time to notify. And then they've also given grace to go up till a little bit later in the afternoon because those that have been summons
Right.
have to call. If you ever have gotten a jury summons, you have to call each day in the evening to see if you're to report to a court the next day. So again, it's a matter of one's interpretation when it comes to were you being helpful or were you overstepping? In my opinion, this city prosecutor overstepped.
Have you experienced pushback from him in court during your tenure?
Yes.
Can you tell us about that, please, and how he treats you?
The impression that I get from Mr. Hersey is anything that I say is a lie.
Have you ever lied in court or to him?
No.
Anything else about the way he treats you?
And it's not just in court.
Go ahead. How else is it?
In setting up the community court program, it required in the grant application process to get information, and part of that is information from the prosecutor and the public defender who would be representative of that program. And for the 1/10 of 1% grant, I do quarterly reports for them. And it requires the statistics, and the particular statistics are unique, and reports are unique to every individual court. So I requested information from the city prosecutor, and the response was, well, I checked with the other courts and they don't do that. So basically he's saying I'm lying. And so, and this has gone on the entire time.
It's also-
Recently,
Go ahead, sorry.
I brought in representatives from the state to sit in on the community court. They have tools and support for community court programs, especially new community court programs, and ongoing because of funding and wanting to be sure to provide the legislature with follow-up information on things that are happening. Produced a tool to evaluate forms and documents. I'm getting feedback, and our point of contact for the state, for us, actually also had worked at Kitsap County. And so she told him, and the statistics, I'm going to say PhD, who was in the room also, said to him that my reporting requirements wouldn't be the same as another court's. And he said, even then, well, we checked with the other courts in the county, and that's not information they have to provide. So again, it's this constantly, and that's just one example of having to prove that I'm not lying. And that this sense of dog whistle language,
Okay,
racist language,
like,
that to the average person,
mhm.
white person, doesn't mean anything. But as a Black woman, means something totally different.
And you're getting
And
that. Oh, go ahead. Sorry, go ahead.
the information that's being asked for or requested isn't going to have any major impact on anything other than them being able to track what's working in the program and what's not working in the program. And this is that pushback. That's gone on since 2023.
And that's just one example, right?
Yes.
Who else besides the city attorney or city prosecutor Hersey did you experience pushback from as a judge?
The entire city council.
Okay. Anybody else?
I'm sorry. The It's one in which saying pushback from city dealing with the director of finance, HR. Policies that are in place or previous things that happened before me became the question of, we, had been asked to do this before. We gave funds and put funds in the budget to do these things, and we never heard anything back from the court.
Never
So
heard back from who?
They never heard back from the court. So
Which,
prior
no,
to me.
thank you.
So I've tried to give updates at city council meetings. I have tried to be more transparent in doing state of the court addresses, providing more information on things that are happening at the court, even the staff turnovers. My most recent address, yes, there has been staff turnovers, but nothing said about nearly the whole entire finance department turning over. Nothing said about Kitsap District Court shutting down every Friday for over a 3-month period. Nothing said about the Office of Public Defense at the county not appointing cases for over a month. But those are all spaces and places where there aren't any people that look like me.
I wanted to ask you about a few people. Ian Cohen, the probation officer. Do you remember him?
Yes.
Did you ever belittle him or speak to him in a condescending tone?
No.
And he talked about a disability. He says he has dyslexia. Did you know that?
He told me later.
So
I don't remember when he told me, but he told me, and it was in the form of a question: did I know that?
right. And so did that come up because you criticized his spelling or said you better spell check or check your email, something like that?
Yes.
Okay. And at the time that you said that, did you even know he had dyslexia?
No.
Okay. Now you talked earlier about not being able to control how people react. Do you know why he's crying? Or said he had tears? Or got emotional in court?
I have no idea. He's, as you saw in the Facebook post, he's been critical of me, but never
What?
never led me to believe in any of the conversations we had, in any of the walks to my car, in any of him coming into my office, telling me about his grandmother, his dogs, plants, just coming in to talk, would have led me to believe that he would, and he felt this way. I'm not sure. Well, I'm 5'4", 5'4.5", petite, in stature, and he's about 6 foot, 6 feet. I've never raised my voice. In any conversations, my concern has always been access to justice and ensuring that we as the court do not present from any staff member that we're giving legal advice. My address and specific comments, as I recall, was regarding legal advice, as the defendant that I recall was pro se. And he asked for some time to go into Mr. Cohen's office to get advice. And those was the defendants. That was what he requested. And so in my opinion, that was the only thing that was being relayed. Mm-hmm. And again, my impression is that there's this belief that this judge, not the previous judge, but this judge should not be talking to anyone or correcting anyone.
Okay, when you say that, the impression you have that there's the thought that you should not be correcting anybody or talking to anybody, are you talking about a group of people that your impression is they feel that way?
Yes.
Okay. And what is that group of people?
Everyone who has testified.
Okay.
And those that are on the witness list, those that were on the original witness list.
Gotcha. And but when you say everyone that testified connected to the statement of charges. I mean, obviously we heard from Mr. Famous, Tyree, etc., and Kiara, but you're talking about those folks that testified against you.
I'm sorry.
You're talking about those folks that have given evidence against you, is that right?
Yes, those that were on the witness list for the CJC.
Thank you. Is your goal to please people or to run a better court for the public?
I am in the elected position that I am in to serve the people, to serve the community, to ensure access to justice, and to ensure that there's due process. And to ensure that there's due process in the proceedings that come before me, the proceedings that I handle.
Have you ever, oh, go ahead. Have you ever heard that saying, you're either part of the solution or you're part of the problem?
Yes, I've heard that saying before.
Does it apply in your case?
I believe so.
Or the phrase about the tail wagging the dog? Yeah, are you getting cooperation from these folks that work for the court?
It's my impression that there is this surface of I'm doing my job, but not really doing my job, because if I really do my job, she could be successful.
And the folks within that group that we've just been talking about, are they all white?
Yes. And no.
I'm sorry, what?
Yes and no.
Okay,
so
explain.
Jennifer Johnson
right.
Told me when I met her, she was Puerto Rican.
Okay.
But she, I believe, has described herself as Puerto Rican and Black. Okay. And as far as staff, the remaining staff, is white.
And is she there anymore, Jennifer Johnson?
No,
Can you, this Stephen DeRosier, Stephen, am I pronouncing that correctly? Stephen DeRosier?
sounds right, but it's not my name, so I don't.
Okay. How is he related to the court, if in any way?
He had been the first therapeutic court coordinator. We secured grant funds and was able to hire him to help get the in October. Yeah, October of.
Well, he showed up at the
22.
Go ahead.
October 2022.
He showed up at the courthouse. We heard from Mr. Tyree. I'm very angry. Had a picture of you, things like that. Were you there that day?
I'm going to object. That is not Mr. Tyra's testimony. Counsel is testifying again.
Bremner?
I can strike that. I just want to move along.
I would like to get truthful testimony on the record. I would request that that be stricken.
I'm fine with striking it, but the interruption I object to, and I'm going to ask another question.
Wait, whoa, Ms. Bremner, you're objecting to Ms. Rasnick objecting? Is that what I'm understanding?
No, I'm withdrawing all of it, Your Honor, and asking another question.
Okay, everything's withdrawn. Go
Thank
ahead
you.
and ask your question.
Thanks. Thank you, Your Honor. Do you know anything about him coming back to the court?
I was informed that he was at the courthouse.
And have you had any restraining order against him or anything like that?
I have a current temporary restraining order.
And why is that?
As it was relayed to me, my staff was fearful.
Objection, hearsay.
That doesn't go to the truth of overruled.
Thank you, Your Honor. Go ahead, Judge Flood.
Again, as it was relayed to me, my staff was fearful for me and concerned for my safety.
And did you ever work with him?
Yes.
And why isn't he working there anymore?
He resigned.
Okay. And do you know why?
According to his letter, for other opportunities.
Okay. But he has animosity against you. Do you know why?
Objection, counsel is testifying again.
Technically sustained.
Do you know why he wouldn't like you?
I can only speak to what I seen on his Facebook post and the fact that he has made derogatory comments about me, that he, in spite of what he said in his letter, had gotten on the same opinion as others who had left, and that was evident too from his friends on Facebook, who included Judge Doctor.
There was some testimony about an incident where you couldn't get on Zoom and came downstairs. Do you remember hearing about that? Do you remember that incident?
Yes.
Okay. What happened in that incident or situation?
I was needing to start a calendar,
Mm-hmm.
and I needed to get in for the calendar I was in the courtroom, and the Zoom had traditionally, from about April of 2022 until October, beginning of October 2022, had been operated by Luann, who had been a full-time clerk, but had moved to Oregon and was put in a temporary position and would do the Zoom, the Zoom controls. And she did that for about 20 to 25. She was limited as to the number of hours that she could work because she was part-time temporary.
Okay.
So I don't believe she was, it was, what I don't believe she was there, as I was not able to get into the Zoom room. So to find out what was going on, I had to come off the bench, go down the stairs, 2 flights of stairs. By the time I got to the door, I was not going to say I'm in sitting for a while. It's in the best of shapes. You're coming down the stairs. It was a little winded. So I didn't go all the way in. I stood at the door because I knew I would need to return to the courtroom. Said, can someone please let me into the Zoom room? I didn't address it at any particular individual because I didn't know who was actually downstairs, but I did see Amber and Miss Kinlow in what would have been my impression was the far right corner. But again, it's me coming down the stairs, looking in, and just making that request.
Did you yell?
I do not believe so. I believe that my voice was at a tone
Sure.
that you could, because again, it's a fishbowl. And the acoustics in the room, my voice would carry over for them to know that I was speaking.
Okay. Had you ever had a position before this position as judge where those that worked for you or worked with you were actively pushing against you in your job before?
No.
And how easy is it to deal with that when you're sitting judge on the bench most of the days and not even able to, I guess you said, go from fire to fire?
It's difficult. Again, I'm not saying everything's perfect in any past setting, but one of the things in the environments that I have worked in is when there's a common goal to see justice served, we all work in unison to be able to do that, whether or not you have differences of opinions or not. You're working to make sure that justice is served. You're in a service position. Government work, this work is service. And as a prior active duty military and as a veteran, it's service before self. You're not being selfish and looking out for your own self. It's the best way that I can.
Have you ever used a rude or condescending tone with any defendant, any lawyer, any probation officer, any court clerk, any employee, any security officer, or any member of the public during the 3 years you've been the judge at Bremerton Municipal Court?
I do not believe so. I believe that my tone has been one that is judicial.
As a judge, do you need to be firm?
Yes,
Do you need to control your courtroom?
yes,
Do you need to control the staff and make sure everybody's rowing the same way, moving the boat forward?
to make sure that everyone is in.
Do you have oh, go ahead. Do you have a sense or impression of whether race has played into all of this in any way?
I do believe so.
Okay, and can you elaborate on your belief, please?
There's a jury video that we use. And in the jury video, Attorney Jeffrey Robinson
I know
puts
him.
up a picture of a white older male in the beginning, and he just flashes it. And he comes back and later says, "What was your impression of the picture that I flashed?" Basically, did you see him as smart? Did you see him as a judge? Did you see him as all of the things that you would think automatically that he was a judge? The Bremerton community, in which I've lived over 30 years and served, and I am the first Black elected judge in 2021 in the city of Bremerton. Judge Spearman, who was in Kitsap Superior Court, was appointed by the governor. He passed away. But I'm a woman and I'm a Black woman. In a city that is the most diverse city in Kitsap County. But our city government does not reflect the diversity in our community. So if you've never worked with someone who is culturally different, and the Black woman is known to be treated as less than, and portrayed as angry and aggressive. And I was called aggressive in the city council meeting. I was told that we could set your salary at $80,000 if we want to. So not only is it internal and inherent in the city that the lack of a welcoming environment is prevalent. In all of these instances, it's the feeling of the honeymoon phase.
Mm.
The first 30 days, everything's exciting and new. You got a new toy and you play with it and play with it. And something happens. Immediately, things look good. You're saying yes. I'm saying yes. But as soon as, again, no, let's change how we do this. Let's try this. My saying, let's try this, is being received as the judge ordered that we do this. And when it's presented that the judge ordered that we do this, it's not being presented that in a positive way. It's being presented as she's telling you how you need to do your job versus let's see if these policies can be changed to do something different. She's taken away something from me. When we're supposed to be a team. That, and it was presented to me, and my impression was, we're all a team, and you're not on. You can't control a person's motivation from the sense of what has motivated them to all line up, in my opinion, against me. Goes to political. And political and biases, implicit biases, explicit biases. The training specifically that was referenced was scheduled from 8:45 to 2 p.m. All trainings and registrations of trainings are done when we're in groups by the court administrator. That information was sent, and again, would have contained the details of the training. So it's little things that an average person, I would think, would say, if the training's from 8:45 to 2, you're a block and a half over from the courthouse, saying you can stay until 2 isn't unreasonable. I tried to motivate, give support and trainings. The training again, the end of May, was a training in empathy, a simulation training. The state has done a great job over the last couple of years in providing a presiding judges and court administrators training. And we attended that in June. And at the time we attended, we were also waiting to hear back from the city on our audit for the 2022 calendar year. And we were so excited, in my opinion, that the audit went well for us, that we didn't have any issues. There was one notation about a receipt, and I think one other notation, but it was a passing audit, thumbs up from the state for the calendar year of 2022. And I believe it went maybe it went a little bit into 2023, but the media has taken things, and there's been things put in the paper about me that have all, in the Kitsap County paper, been just as negative picture, this, what I would term public lynching, that the city approved funds for the city prosecutor to send cases to the county because it was such an emergency, and no case was ever sent to the county. We get cases dropped down from the county all the time, though. Pretty consistent. That this narrative is very political. Even Mr. DeBrozier saying he hired Mr. Weaver, who ran against me. Stressful to the place of me being at the hospital with my husband, being told that I wasn't doing enough while at the hospital with my husband. I agree to the stipulated facts because I want to accept responsibility for myself. And GR 29 and telling me I'm responsible as the presiding judge as to what happens in my court. But what it does not do is put forth the rudeness and disrespect that I deal with on a daily basis. Hearing every day, your staff believes you're mean, you're mean. Was I mean when I gave you an alternative schedule when you had only been employed there for 2 weeks? Was I mean when you spent all day on the phone with Social Security? When you needed to be off of court? When you tell me you need to leave early because you got a family emergency, when you need to come in late, when you need to take leave without pay? Was I mean when you said you want to do A, B, and C, and I said, okay? I was mean when I said, no, send that to me in an email. And to say that I made some type of eking sound, am I being called, and that's racist in tone, am I being called a monkey? By your implication that I said, I'm making some sound or I'm looking some way. On my bench, again, I'm 5'4". My feet dangle when I'm sitting in my chair. I have 2 large screens in front of me when we're in the courtroom. The prosecutor's desk, I can barely see sometimes, unless I'm turning back and forth. When I'm on Zoom, I have 2 laptops set up. One with the Zoom, one with all of my jabs and courts and all of those things. The majority of the time, you're seeing the side of my face. And to be said, eye rolling, stares, I'm staring at the screen. This is the typical angry Black woman that is being presented. This is a very isolating job. Judges are very isolated. Your circle shrinks when you become a judge. My time is spent on the bench, in committee meetings, working with the city. Lots of different hats to be worn. I don't spend my time down in the clerk's office trying to figure out what's going on or trying to impose anything on anyone. It's a quick check-in here, check-in there.
Ms. Brebner, I apologize to interrupting here, but we've been going on at some time with this answer. I'm not, and it is close to the noon hour. I did ask for more directive questioning. I'm not sure that's happened. I do want to be incredibly sensitive to, as you pointed out, having the witness testify in her own words and in her own way, although there is a responsibility of me to make sure that we are proceeding in a way that's consistent with the way direct examinations work. I do want to ask you about the remaining duration of your direct examination. We've been going on now throughout the morning. Time is now 12:04. How much longer do you think you have as I try to evaluate when to take a noon break?
Well, Your Honor, I would say it would be 5, probably under 10 minutes.
Okay, so let's proceed and eyeball 12:15 for a closure of your direct. And at that point, I expect to take a 30-minute break for lunch before we begin cross-examination. Go ahead and continue. My apologies for the interruption.
That's right. Thank you, Your Honor. Judge Flood, you were just talking about the position of a judge being isolating and talking about the difficulties you have. And I think you left off talking about that you don't go down to the clerk's office. You've got meetings, you've got court, things like that. What else were you going to say about that in terms of your response to these allegations or accusations?
It's hard to really kind of think the best way to say it is the clerk's office being downstairs, the courtrooms being upstairs. There's a lot of separation there. And historically, I believe that there's this sense of in court administrators code that exists. There's an unspoken code that and this, if you do something that I don't like, you'll see. Because there's a lot of things that happen that judges don't see and don't know, that we are not aware of. So if the person who you should be able to trust to carry out the things that they say they will carry out isn't happening because they disagree with you, there's no way to know that. And there should be a fine separation between the city prosecutor's office and the court. But in the past, this court has taken on, under the previous administration, a lot of duties that should have not been being done by the court. And that does not sit well with that office.
Thank you. That's all I have.
Thank you, Ms. Bremner. Before we break for lunch, Ms. Rasnick, let me ask you, what's your expected duration of your cross-examination?
Well, Your Honor, it depends on whether the judge is able to give direct answers, frankly. I have a cross that I think would take about an hour. But honestly, I cannot predict how long it will take. I wish I could, but I just feel as though I can't. The best I can tell you is that as I wrote it and based on my experience having been a litigator for 25, 26 years, I look at a cross of this length and I ordinarily think it's going to take about an hour, maybe an hour and a half, but I just don't know what to expect. And I'm sorry that I can't be more helpful on that score.
May I be heard on this, Your Honor?
Ms. Bremner?
They've already taken her deposition. As I understand it, it's 2 volumes, so they understand the way that she answers and at what length and breadth. And so I just want to make sure we can get this completed today. I don't want to have to be back next week. I know nobody does, but given that we want to do closings, I just hope we can keep this on track. And I practiced 40 years. I mean, I shouldn't be practicing anymore after all that, but I think this is just something you put up, that you have to deal with. You have to expect, that you should be familiar with the way this witness testifies. And there's been 2-volume deposition that we weren't privy to. Previous counsel was privy to it, but I believe that counsel for the CJC was part of that, if I'm not mistaken. So I just wanted to be heard on that.
All right. Well, my recollection, Ms. Bremner, is you estimated your direct at being about an hour.
I did.
And so obviously you were somewhat wrong about your estimation of time as well. So I think that I'm not casting aspersions. I'm just suggesting that Ms. Rasnick's uncertainty with time certainly might be mirrored with your own. But I do want us to be efficient, Ms. Rasnick. I want you to be efficient with your cross-examination without, of course, unnecessarily telling you what to do. So at this point, let us take 30 minutes for lunch. 30 minutes. It's now 12. It's 12:11. Let's go 12:40. Oh, let's go 12:45. 12:45, we will resume with the cross-examination of the witness. That's slightly more than 30 minutes. 12:45. Let's see everybody back here. We'll be in recess.
Thank you, Your Honor.
There she is. All right. Welcome back, everyone. We just are returning from our lunch break. Time is 12:45. We're ready to begin with the cross-examination of the witness. Ms. Rasnick, are you ready to go?
I am.
All right. Ms. Bremner, are you ready to go?
I am. Thank you, Your Honor.
All right. Please proceed, Ms. Rasnick.
Good afternoon, Judge Flood. Can you hear me okay?
Yes.
Okay. You have admitted that you verbally admonished your staff for not following instructions. Is that right?
I have admitted to what's in the stipulation.
Okay. Does the stipulation include verbally admonishing your staff for not following instructions?
I'll object unless it's shown to the judge. If we're referring to a document, I think it should be shown to her.
Overruled, at least at this point. We'll see what the answer is.
I believe that it contains some language to that effect. From my memory,
Right. Let's take a look at it. Judge Flood, do you see the document that's being shared?
yes,
Okay, I'm going to scroll up to the top. Do you read that it says stipulation to facts and code violations? Did I read that correctly?
I see it.
Okay, did I read it correctly?
I didn't hear everything that you said, but I see it. Yes. So you kind of faded. So
Do you see that it says stipulation to facts and code violations?
in my answer, yes, I see it.
Thank you. Just going to scroll all the way down. This looks like an Adobe sign or a DocuSign. Do you remember electronically signing this document on October 21st, 2024?
Yes,
Okay. Did you also verbally admonish your staff for making mistakes?
I believe the document speaks for itself, ma'am.
So you agreed in this document that you verbally admonished your staff for making mistakes?
I believe the document reads, at times respondent verbally admonished staff for not following her instructions for making mistakes.
Thank you. You also agreed that you communicated with them in a manner that was pointed and harsh,
It says,
correct?
though respondent rarely raised her voice, her communication could be pointed and harsh.
So you agreed that you did communicate with your staff in a way that was pointed and harsh?
Objection. The document speaks for itself. Asked and answered. Argumentative.
Overruled.
I'd ask the court to direct the witness to answer.
Could you repeat your question?
You admitted that you did communicate with your staff in a manner that was pointed and harsh, correct?
I agreed that it could be.
When you agreed that it could be, did you also agree that it sometimes was?
I believe that it could be.
Okay. You agreed that you could be condescending to your staff, correct?
I object again unless the document is used in reference, Your Honor.
Overruled.
It says when that happened, when that did happen, respondent could be condescending, which made some staff feel humiliated, embarrassed, and anxious.
I'd ask the answer be stricken as non-responsive and the court direct the witness to answer the question.
I take exception, Your Honor.
I'm denying the motion to strike the answer, but the witness needs to listen closely to the question and answer the questions that's asked.
I'm going to try that again, Judge Flood. So by signing this stipulation, you admitted that you could be condescending to your staff.
Objection is asked and answered. Argumentative.
Overruled.
The stipulation states that.
But you don't believe that's really true.
The stipulation is what I agreed to.
I'm asking you a different question. Do you believe that's really true?
I'm not understanding your question.
What part of it don't you understand?
You're asking, what are you asking? Maybe you should restate the question.
All right. You said you agreed when that did not happen, respondent could be condescending, correct?
Say that again. I'm sorry. I'm not
Okay.
understanding if you're asking me if I said something or if the document said something.
Okay. Do you agree that the document says when that did not happen, respondent could be condescending?
Yes, I agree. The document says that. Yes, we have that in front of us. Yes.
Okay. Do you agree that it's true that you could be condescending to your staff?
Same objection, same basis.
Overruled.
Do I believe that this is true? The statement or the stipulation?
I'm going to ask that that be stricken as non-responsive and the witness instructed to answer.
I would take exception.
Yeah, I'm not striking the answer, but clarify the question. Ask it one more time, please.
Okay. Is it true that you could be condescending to your staff?
I believe that that is the opinion of some staff, and as a way to accept responsibility, this is what is in the stipulation.
Okay. Do you agree that the stipulation says you made some staff members feel humiliated, embarrassed, and anxious?
Same objection, same basis.
Overruled.
Can you repeat the question?
Do you agree that the stipulation said you made some staff members feel humiliated, embarrassed, and anxious?
The stipulation says that.
Do you agree that you did make some staff members feel humiliated, embarrassed, and anxious?
That's what I have been told, and that's what I have heard. So
Okay.
I can't control another person's feelings, and I don't know outside of what's been told to me how a person is feeling.
Do you agree that the stipulation says some staff believed that you did not clearly communicate your expectations of them?
Yes, that is what the stipulation says.
Is it true that you sometimes didn't clearly communicate your expectations of them?
I'm sorry, can you repeat the question?
Is it true that you sometimes didn't clearly communicate your expectations of them?
From the information that I have, yes, sometimes because there was clarifications being asked. So yeah, there was sometimes where things were not clear.
The stipulation says that you chastised them if they didn't understand what you wanted. Do you agree that's what the stipulation says?
Yes, that is what the stipulation says.
Is it true that you chastised staff when they didn't understand what you wanted?
That is what was described to me.
Is it true?
Objection is asked and answered.
Ruled.
I need for you to repeat your question.
Is it true?
Under the definition and what was described to me and how people felt, sometimes.
The stipulation says you denied having given unclear instructions. Is that correct?
Yes. Yes.
Did you deny having given unclear instructions?
Yes, that's what the stipulation says.
But did you deny having given unclear instructions?
Yes.
The stipulation says that staff often heard you to respond, "That's not what I said," or "I didn't say that," in response to their concerns. Do you agree that that's what it says?
That's what the stipulation says.
And do you agree that you would respond, "That's not what I said," in response to staff concerns?
Yes.
And how about, "I didn't say that"? Do you agree that you would respond, "I didn't say that," in response to staff concerns?
Yes.
The stipulation says that some of your staff became increasingly wary of engaging with you. Do you agree that it says that?
Yes, that's what the stipulation says.
And do you agree that's what happened? That some of your staff became wary of engaging with you?
Yes, that's what some staff has said.
You were a practicing attorney before you were elected a judge, is that correct?
Yes.
Do you agree that it's the job of a practicing attorney to push back on the judge in court?
Objection, form of the question, and it's vague.
overruled, given the use of that term throughout the direct examination.
No. I believe it's the job of a good attorney, a defense attorney, to advocate for their client. There's a difference in pushback and advocation.
Do you agree that it's an attorney's job to disagree with the court?
It's an objection.
Yeah,
I don't know that.
hang
I'm
on,
sorry.
I'm going to sustain that objection. I'm not sure what that means.
You testified you are a graduate of the Washington Law Institute. Is that right?
The Washington State Leadership Institute.
Okay, thank you for the clarification. You also attended Judicial College?
I attended Judicial College in Reno, Nevada, and the general jurisdiction, and I attended Judicial College for the state as well.
And after the CJC contacted you about the complaints, you worked with a coach. Is that right?
I worked with coaches throughout my career.
Do you remember, are you familiar with a woman named Talisa Lavari, Lavarry? She goes by Tally, Tali.
Yes,
You worked with Ms. Lavari as a coach. Is that right?
I worked with her to do some work with me in the court.
And you chose to work with Ms. Lavari. Is that right?
Everyone that I work with, I have chosen to do so.
Is that a yes? You did choose to work with Ms. Lavari?
Yes,
And when you chose to work with Ms. Lavari, that was after the CJC had contacted you about the complaints. Is that right?
no,
Your testimony is that you worked with Ms. Lavari before you heard from the CJC about the complaints?
I talked and made arrangements with Miss Lavari before I heard from you.
And did you continue to work with Ms. Lavari after you heard from the CJC about the complaints?
Yes, I worked with a few people after I heard.
And you testified that you've really recently been through empathy training. Is that correct?
The training that was mentioned by the court administrator was a resiliency summit with a focus on empathy through a simulation. So it per se, if you want to say that it's an empathy training, then you could say that. But it was a focus on individuals in the system having empathy for defendants and incarcerated individuals and those that have had contacts with the system. So that simulation was based on the role play of being put in jail, having $20 to survive on a month. What do? Do you take a UA for your probation, or do you buy food for your kids? So that was a simulation in empathy for the defendants.
Thank you. Dawn Williams was the court administrator at Bremerton when you took the bench in 2022. Is that right?
Yes.
And Dawn had a lot of institutional knowledge as the court administrator. Is that right?
Jeff, lack of foundation.
Overruled.
Can you ask your question again?
Dawn had a lot of institutional knowledge as the court administrator. Is that right?
Institutional knowledge. Is your question about Bremerton? Is it about a court administrator? Or
Let me come at this a different way. Dawn Williams, is it fair to say she had been the court administrator for 11 years?
I don't know that for sure.
Did you have any understanding of how long she had been the court administrator when you
No.
took the bench?
I did not.
Did you later develop an understanding of how long she had been the court administrator?
I I understood that there had been a previous court administrator to her that she replaced, but I do not know. I did not know the time.
Did you later come to learn that Ms. Williams had been the court administrator for 11 years?
Objection, asked and answered.
Apologies, I couldn't get my clicker. I'm gonna permit the question one more time. Overruled.
What was the question?
Did you later come to learn that Ms. Williams had been the court administrator for 11 years?
I again, I do not know the exact time.
Did you benefit from Ms. Williams' knowledge as the court administrator?
On the things that she shared with me.
I was going to object, it seems fast because facts, not in evidence, because she doesn't know her experience, but the answer, go ahead. I'd say the judge should just go ahead and answer to expedite this.
Yeah, okay, overruled. The objections overruled. Go ahead and answer.
On the things that she shared with me.
And in the stipulation, you admitted that Ms. Williams experienced you as constantly critical of her. Is that right?
I don't know if that's something specific or not, but what's in the stipulation is what I admitted to. I'm not understanding why the things that are in the stipulation are what I stipulated to and admitted to, and I'm accepting responsibility for today.
Do you agree that you were at times constantly critical of Ms. Williams?
And I object. She stipulated this. It's in the record. It's before the commission. ER 403, waste of time.
I'm gonna overrule based upon the direct testimony. Overruled.
Can you repeat your question?
Do you agree that you were at times constantly critical of Ms. Williams?
Are you, I would ask that if that's what the stipulation says, for me to be able to see it, because I don't remember everything that is in that stipulation.
I'm not asking you about the stipulation, Judge Flood. I'm asking you if you agree that you were at times constantly critical of Ms. Williams.
Your Honor, I do have to object. If she's referring to a document, it should be shown to the witness. The witness has asked for the document, and she appears to be quoting from it. So that's my objection.
Okay, overruled. Question is not related to a document.
I believe I hear you saying two things. So I'm going to try to answer your question. You said at times, constantly. At times and constantly does not go together. So my response would be, at times I feel and have been informed and am accepting responsibility that Dawn felt that I was critical of her.
Right? You also stipulated that Ms. Williams believed that nothing she could do would satisfy your expectations. Is that right?
I believe that if that's contained in the stipulation, then yes.
Okay. Do you agree that it was difficult for Ms. Williams to satisfy your expectations?
I don't know. I don't think I can answer that question. I believe she may have felt that way. And I can acknowledge that she felt that. I can't do any more than that.
Judge Flood, you reached out to Courts Helping Courts in September 2022. Is that right?
Yes,
And you asked Trish Kinlow for help at your court. Is that right?
yes,
And you told Ms. Kinlow that you thought the trouble at the court was because of racism. Is that right?
not specifically in those terms.
How did you put it when you told Ms. Kinlow that?
I believe the conversation was I was concerned because of an incident that happened with an employee calling me by my first name, and that I'm experiencing micro and macro aggressions in the behavior of the staff, and that I was told to reach out to her, um, that there could possibly be some support that she may know about, and to ask her for assistance. She told me that I should definitely talk to HR and send an email to Courts Helping Courts. And then I don't
Okay.
know if we scheduled a follow-up after that.
Okay, I'm going to ask another question. All right, I'm mindful of our time. I don't mean to cut you off, but I'm very mindful of our time.
Your Honor, I object. She should be allowed to finish her answer.
I'm going to permit the question, another question to be asked.
Okay. Who suggested you reach out to Courts Helping Courts?
A judge friend.
Who was the judge friend?
I believe it was Judge Chess.
You mentioned that you had told Trish Kinlow that you were experiencing microaggressions and macroaggressions. Is that correct? Did I get that right?
Yes,
And microaggressions and macroaggressions are racism. Is that right?
they're forms of biases
Are they forms
that
of,
are,
I apologize, go ahead.
so to answer your question, it's forms of that fall in that category of inequity, racism, biases, implicit biases, explicit biases. Overall,
This is what you told Ms. Kinlow.
it was in conversation, so it was a general, fast conversation. It wasn't getting into any details as to who I was saying that it was from. I said I was experiencing it at the court.
And was it your impression that Ms. Kinlow understood you to mean you were experiencing racism at the court?
I don't know what Ms. Kinlow took from that other than me asking for help.
And Ms. Kinlow is a Black woman, is that right?
Yes.
When Ms. Kinlow and Jennifer Johnson came over to Bremerton Municipal Court to help, you welcomed them, is that right?
Yes.
You were really happy to see them, is that right?
I was relieved.
You were relieved to see them. Did I hear you correctly?
Yes,
Do you remember saying to them that they were your guardian angels?
I was referring to the program of court helping courts as they were there representing court helping courts. So yes, in
Okay.
that context, context,
And Ms. Johnson is Black and Mexicana. Is that right?
that's what you have in the paperwork. She told me she was Puerto Rican.
Okay. Do you have any reason to think that she's not Black and Mexicana?
She told me she was Puerto Rican.
I see. Do you believe her that she's Black and Mexicana?
I believe what she told me. So I believe that in the Latin, American, Mexican American, when you're talking different cultures and countries, some people who are of mixed descent like that refer to themselves at times as Puerto Rican. Some of them refer to themselves as time as Black and Mexicana as you're describing here. But what I'm saying is she told me she was Puerto Rican.
Thank you. As the judge at Bremerton Municipal Court, you get to decide whom to hire as court administrator. Is that right?
Yes,
And you decided to hire Jennifer Johnson as court administrator. Is that right?
based on the recommendations from the hiring panel. I put together a hiring panel for the court administrator's position after Dawn left to replace her. I hadn't made any decisions prior to that. And in putting together that hiring panel, both Trish Kinlow and Jennifer Johnson agreed to be a part of that hiring panel. So Jennifer Johnson was actually a part of the hiring panel. She then asked Miss Gale, can't remember what court she's from, to replace her on the hiring panel. After applications began to come in, she then emailed and said that she was going to apply and asked Gail to replace her on the hiring committee.
But the decision to hire Jennifer Johnson as court administrator was yours in the end, correct?
I took the advice of the hiring panel. My ultimate being the one that signed the letter, I was the only one that could sign the letter. I was the only one who was on staff at the city. So my hiring panel made a recommendation and I adopted that recommendation.
Thank you. You could have contacted Judge Leone as a reference check for Jennifer Johnson, right?
I could not contact Judge Leone because Jennifer Johnson did not give me her telephone number. And she told me that Judge Leone was on bereavement leave and not available. So I could not contact her.
Your testimony is that Jennifer Johnson prevented you from contacting Judge Leone?
My testimony is that I did not get the telephone number for Judge Leone from Jennifer, that Jennifer Johnson told me that Judge Leone was on bereavement leave. That is my testimony. So I did not get a chance to talk to Judge Leone before I hired Jennifer Johnson.
You didn't take any steps to try to locate Judge Leone's contact information?
I did not want to, if being respectful that she was on bereavement leave, I did not want to impose during that time.
You saw the former probation officer, Ian Cohen, testify earlier this week. Do you remember that?
Yes,
Do you remember seeing Mr. Cohen break into tears a couple of times while he was testifying?
I saw him wiping his face.
You just sort of smiled a little bit. Why did you smile when I asked you about Mr. Cohen breaking into tears?
Because your description is breaking into tears. I saw him wiping his face. So that's a difference of your opinion is that he broke into tears. My opinion is that I saw him wiping his face. I wasn't watching his every move. So descriptions are very important. And you're, of course, the prosecutor. So your description is one of a prosecutor's.
Thank you. Do you agree that the stipulation states that Mr. Cohen experienced you as constantly critical of him?
I
Objection.
know the
That lack of foundation speculation. She's asking what he thought and what he perceived. And the stipulation speaks for itself and should be shown to the witness in any event if it's being used.
Well, I'm going to sustain the objection unless the question is, does she, it's to me a fair question whether whether she remembers what's in the stipulation, but if you're going to ask her if it's in the stipulation, that to me needs to, I'm going to sustain the objection with respect to that being an aspect of the question. I'm not sure I understand the question.
Okay. I will try it again. Judge Flood, do you recall that the stipulation states Mr. Cohen experienced you as constantly critical of him?
Same objection, same basis.
That one's overruled.
Can you please ask your question again?
Judge Flood, do you recall that the stipulation states Mr. Cohen experienced you as constantly critical of him?
I do not recall specifically what the stipulation states as to Mr.
Okay. Let's take a look at it. Are you able to see the document?
Yes.
Okay. I would direct your attention to the first sentence of paragraph F. Does that sentence say that Mr. Cohen experienced you as constantly critical of him?
Objection less than spread in its entirety and context.
Overruled.
So from my read of it, the probation officer, Mr. Cohen, also experienced respondent as constantly critical of him and believed that nothing he could do would satisfy respondent's expectations. Yes, that's what I agree to, and that is the full sentence.
Okay. Were you critical of Mr. Cohen?
In the sense of bringing things to his attention that needed to be corrected, that is termed as critical, yes.
And did he have difficulty meeting your expectations?
From my understanding, yes.
Was your experience that he had difficulty meeting your expectations?
In some conversations with Mr. Cohen, he would say, Judge, I'm trying to not do things the way that Judge Doctor did them, but trying to learn your new way of doing things. So with that, that leads me to believe and admit to in these proceedings that he had difficulty. Because again, he said he had done things for so long, Judge Doctor's way, and the way that things go, that he had difficulty making changes.
All right. I'm looking a little bit farther down in that same paragraph F now at the beginning of the next page. This sentence says that Mr. Cohen felt humiliated by your treatment. Do you see that?
Yes,
You agree that Mr. Cohen felt humiliated by your treatment.
Objection, speculation, and what he felt, or that she can agree to it.
Overruled to the question, to the narrow question, overruled.
what was the question?
You agree that Mr. Cohen felt humiliated by your treatment. Is that correct?
Again, the stipulation language is based on what I have been told as to how he felt. And it states that Mr. Cohen felt humiliated. So that
Right.
is what I am agreeing that he has said that he felt. So yes, but I can't
Right. Thank you.
determine another person's feelings.
Thank you,
I
Judge
can't
Flood.
testify and say, I know only that person has their feelings.
Thank you, Judge Flood. I'm going to move on now. You hired Serena Daigle to work for Bremerton Municipal Court. Is that right?
Yes,
You
Serena
hired,
came to us through court helping courts as well.
right. And then you hired her to work for the court. Is that right?
Yes, Serena indicated that she, through text messages, she wanted to be my sidekick. She had hoped to be the court administrator.
Okay. And you agreed that she would be a good fit as an employee of the court, so you hired her.
Actually, I first interviewed Serena for a court administrative position. The panel said that she would not be a good fit.
So you hired her for a different position.
I then listed the position of senior legal technician, and Jennifer Johnson wanted to bring her on. And so Jennifer Johnson wanted to work with Serena because she said she had worked with Serena at Des Moines. My choice for that senior legal technician was different from Jennifer's.
But you agreed to hire Serena.
Yes, because the court administrator said that she had the experience and could work with her.
Right. You agreed in the stipulation that you spoke to Serena Daigle in a manner that she felt was impatient and discourteous. Is that right?
I believe the stipulation says on one occasion when Ms. Daigle was filling in the courtroom and Ms. Daigle asked the respondent to clarify a ruling in court, respondent spoke in a manner Ms. Daigle felt was impatient and discourteous.
Do you agree that you spoke to her in a way that was impatient and discourteous?
Objection, asked and answered.
Overruled.
I believe that she felt the response was discourteous and impatient.
You admitted raising your voice and yelling across the clerk office at Amber Dodge on that incident that you talked about during your direct exam. Is that right?
No,
You did not admit that you raised your voice and yelled across the clerk's office at Amber Dodge?
Object, it's asked and answered.
Sustained.
Did you stipulate that you shouted at Amber Dodge across the clerk's office?
I believe there's language in the stipulation. If you want to refer to that, you should bring it up.
All right. I'm looking at paragraph NA, which is starts on the bottom of page 4. I'm looking at this sentence. So you admitted that in a raised voice, you shouted at Ms. Dodge, "I have been waiting in the Zoom waiting room for over 10 minutes. Will someone please let me in?" Is that correct?
Objection unless it's the rule of completeness, the full sentence, paragraph, context isn't being shown or referred to.
Well, the entire paragraph is being shown.
It-
What aspect of the paragraph is not complete with respect to the sentence that was read?
Well, anytime, Your Honor, that it's not read for the full sentence, just part, I think is a proper objection.
Did you read the full? I'm sorry to interrupt. Did you read the full sentence, Ms. Rasnick?
I did not, but I certainly can. But the full
Okay.
sentence is visible to everyone.
That's my objection, Your Honor.
Okay, read the full sentence, please.
Sure, I'll rephrase the question. Judge Flood, did you admit in the stipulation, standing in the doorway at the other end of the room, respondent in a raised voice shouted at Ms. Dodge, "I have been waiting in the Zoom waiting room for over 10 minutes. Will someone please let me in?"
Same objection. There's, unless I'm not seeing this correctly, it looks like there's a dash before the standing and there's further language before that.
Overruled. That dash looks like a footnote.
Like a what, Your Honor?
To me, it looks like a footnote. Objection's overruled.
Oh, all right, thank you.
So what the stipulation states is raised voice and shouted, not yelled. And I was standing in the doorway. I was not in the room. Because as I described, the stairs come right down to the doorway, and I was a bit winded. They were on the other side of the office. I did not step into the clerk's office. So it was a raised voice. And because I was standing in the doorway, and then yes, you have the shouted because I'm in the doorway. I'm not in the room. So to answer your question that you're saying from the other side of the room, no, I was in the doorway. And yes, as to the raised voice and the language there where it says, I've been waiting in the Zoom room for hearings to start for 10 minutes. And that's what I testified to, that I was trying to start court.
You heard Latricia Kinlow's testimony that Amber cried after you shouted at her, right?
I heard the testimony, yes.
Did it surprise you to hear Ms. Kinlow testify that Amber cried?
Yes.
And you heard Ms. Kinlow's testimony that she had never heard a judge speak to an employee like that. Did you hear that?
Yes.
And did that surprise you when Ms. Kinlow testified that?
Yes.
Do you recall an employee named Brian Knowles, Knowles?
Yes.
You hired Mr. Knowles, is that right?
Yes.
Mr. Knowles is Black?
Yes.
You admitted that you were impatient and discourteous to Mr. Knowles, is that right?
Same objection in rate stipulation, it being properly shown to the witness.
Overruled.
If you can state your question one more time.
You admitted that you were impatient and discourteous to Mr. Knowles. Is that right?
I believe there is a paragraph in the stipulation that Mr. Knowles is discussed with a particular incident in I believe Miss Johnson's office. So I do believe that there is some language there, yes.
But you don't remember admitting to being impatient and discourteous to him?
I don't remember the exact language that is in that paragraph, but I did stipulate to the language that is in that paragraph.
All right, let's look at that. Right, I'm looking at page 5, paragraph C. It starts on the bottom of page 5. You stipulated that when Mr. Knowles began to stand up, you told him firmly to sit down.
Again, I
Is
object
that
unless
correct?
a full sentence is read, Your Honor. It's part of a sentence.
Well, can you read the full sentence, Ms. Rasnick?
You stipulated respondent told him firmly to sit down. Is that correct?
That's not the full sentence, Your Honor.
I don't know where I don't know where you're at.
Okay,
I'm sorry. I don't.
let's look at page 5. Do you see page 5?
Yes.
Do you see line 20 of page 5? Right here? Do you see my cursor?
Yes, but that's not the beginning of the sentence.
That's right. I think we have been through this before. Do you see the sentence that says respondent told him firmly to sit down?
Same objection.
Overruled.
Yes, I see the sentence.
You stipulated to that, correct?
Yes.
The next sentence says, I'm looking at the very next sentence. Respondent admonished Mr. Knowles, then remarked that the admonishment had been a teaching moment for him, period. You stipulated to that, correct?
Can you pull the full thing on the screen?
Sure.
All of the paragraph.
I'm doing it right now. On the full paragraph,
Mhm.
I think that would make it pretty small, but sure. There you
So
go.
I believe paragraph C is in reference to Brian Knowles. And I stipulated that in February 2023, respondent called Jennifer Johnson, whom she had hired as a court administrator in November 2022. And Brian Knowles, a legal technician, when responded, had hired him in December 2022 into Ms. Johnson's office. Respondent asked Mr. Knowles about an issue with a judgment and sentence he had completed while working with a remote pro tem judge. Mr. Knowles began to stand up. Respondent told him to firmly sit down. Respondent admonished Mr. Knowles, then remarked that this admonishment had been a teaching moment for him. Respondent now recognizes she talked to Mr. Knowles in an impatient and discourteous manner. That is what I am acknowledging and have stipulated to.
Right? Part of that stipulation is that you talked to Mr. Knowles in an impatient and discourteous manner. Is that correct?
That is included in that paragraph, yes.
You heard Jennifer Johnson testify about this incident in her office with Mr. Knowles. Is that right?
I don't remember that testimony.
You saw Ms. Johnson cry when she testified about this incident. Do you recall that?
No. I don't recall the testimony about this incident, so I can't recall her crying about it. There was a lot of testimony. I do recall Ms. Johnson wiping her face and holding her head down and asking for a moment, but I do not remember what part of the testimony that was.
Right. Were you acquainted with a gentleman named Maury Baker? Maury, Maury Baker.
What is the question?
Are you acquainted with him?
Yes, I know Maury Baker.
And he volunteered his time to help out at Bremerton Municipal Court. Is that right?
Mr. Baker reached out to the mayor, asked the mayor and to pass on his contact information to me. Me and Mr. Baker met for coffee in Silverdale and talked. And he said that he would be willing to help with training a court administrator, as I was aware that he had been a retired court administrator for Kitsap County.
And Mr. Baker then came in and volunteered in the courthouse for several months. Is that right?
2 months.
You appointed him some sort of an advisor to the court. Is that right?
He asked to work in an advisory capacity.
And you
And he
appoint,
asked,
go ahead, Judge Flood.
to work in an advisory capacity. And he said that he didn't need to be paid as an interim or anything. So because he was retired and he just wanted to help train, again, the staff and the court administrator.
So you accepted Mr. Baker's help. Is that fair to say?
Yes.
You welcomed him when he offered to help you. Is that fair to say?
I invited him in. So I'm not, when you say welcome, it was my invitation.
And when Mr. Baker stopped volunteering in August of 2023, he conveyed to you that the court was as good as it was going to get under your chain of command. Is that right?
Me and Mr. Baker did not talk before he left. He told me he would see me the next day, and he did not see me the next day. At the end of that day, I was sent a message from HR that he had announced that the end of the day would be his last day. So I did not have a conversation with him. What you're referring to, I learned from HR.
Right. I'm going to share a document that's been identified as Disciplinary Council's Exhibit 226. Take a look at this, Judge Flood, and let me know if you have seen it before.
Was there, I didn't hear your question.
Okay.
What did you want me to tell you?
Mr. Baker says in this letter that it's been an honor to work with the staff of Bremerton Municipal Court, past and present. Do you see that?
Yes.
And then he goes on to say, as of the writing of this letter, I can report that the court's current level of functioning is as good as it will get under your chain of command. Do you see that?
Yes.
And then he goes on to say, I sincerely believe that you desire to lead the court in a positive direction in order to serve the best justice for the citizens of Bremerton. Do you see that as well?
Yes.
And then he concludes, it is my conclusion that your decisions and behavior are not conducive to that goal. Did I read that correctly?
Yes.
Did you receive this letter from Mr. Baker?
No, I didn't receive it from him. Again, I received it from HR.
Okay. This is the letter you received from HR.
Actually,
I'm going to offer.
eventually I received it. I believe
All right.
maybe an electronic version or something in an email with this information in it.
Okay.
With the
Just scanning all the way up and down.
with the PAF.
Appreciate it. Disciplinary counsel offers exhibit 226.
Objection, Foundation.
You're muted, Your Honor.
Okay. Thank you. I was going to say I have not asked for your response yet, Ms. Bremner. I was going to say, as I always do when an exhibit is offered, 226 has been offered. Ms. Bremner?
Foundation objection, relevance 403.
Ms.
Hearsay.
Rasnick?
And hearsay.
Ms. Rasnick, your response?
The witness has testified, the witness has authenticated the document, has testified that she recalls receiving it. It is probative of issues that are in controversy, as Ms. Bremner has repeatedly used as the basis for admission of documents, and it's being used on cross-examination.
I haven't used any documents.
Well, the document was appropriately used as an impeachment exhibit, but admitting it as substantive evidence is not something that would be appropriate. I'm going to sustain the objection.
Right.
And we'd like to, if we could ask the court to advise the panel to strike.
I'm not going to strike the exhibit. I will tell the panel that it was used for impeachment. You're not to view the letter or recall the letter as substantive evidence.
Thank you, Your Honor.
Let me ask about Serena Daigle again. When Serena Daigle, do you recall Serena Daigle resigning in May 2023?
I don't know the exact date of when she resigned, but I do recall that she had hired an attorney, and there was some back and forth with her asking for some accommodations, and the response was that the accommodations didn't come in time, but I don't know the exact date.
Do you recall Ms. Daigle testified by declaration that she resigned after consulting with a physician? Is that correct?
Objection based on hearsay and not shown to the witness.
Can you repeat the question, Ms. Rasnick?
Sure. When Ms. Daigle resigned, she said she was doing so after consulting with a physician. Is that right?
Same objection.
Yeah, I'm going to overrule the objection. It doesn't go to the truth, in my view, based on the purpose of the questioning.
Sure. Do you recall, Judge Flood, Ms. Daigle communicating that she was resigning after consulting with a physician?
I do not know as to any specifics, as at that time, Ms. Daigle was represented by an attorney, and I believe the communications were going from the counsel assisting the court and her counsel and the interim or the assistant court administrator at the time. So I can't say specifically.
And in her resignation letter, Ms. Daigle called the work environment at Bremerton Municipal Court hostile. Is that right?
Objection calls for hearsay.
Um, I'm going to sustain the objection. I'm not sure where the foundation for the question is coming from.
Do you recall seeing Ms. Daigle's resignation letter?
I do not specifically.
Did Ms. Daigle ever communicate to the court that the work environment at Bremerton Municipal Court was hostile?
Not that I can recall.
Let's take a look at this document.
I'll object to this being shown to the panel, Your Honor. It's hearsay, and it's being shown right now without, I understand the problems with this format, but it is hearsay, and there is actually a way to, in my experience in my trials, whether it's electronic trials or in person, that you can show that to the witness first electronically before showing it to the jury or the panel.
I'm going to overrule the objection with respect to the format. We've been doing it this entire way, and an objection this late as to the format will we're not going to change what we're doing here this late in the game. However, if the matter is not admitted, I'll appropriately instruct the panel with respect to the way they treat the exhibit.
And I would just indicate I'm not being delayed on this. It's just that these are the first times I felt there should be an objection to these being shown to the jury. So that's all I have to say. Thank you.
Judge Flood, does this refresh your recollection of what Ms. Daigle communicated to the court?
No, it does not. This letter is not addressed to me. And there were several resignations that I rarely saw that would be received, and I was just told that they were received.
Right? You testified that you didn't recall this is a letter directed to Bremerton Municipal Court. This does not refresh your recollection of what was communicated to Bremerton Municipal Court.
This letter is addressed to Jennifer Johnson, Bremerton Municipal Court. It was not addressed to me, and I do not recall receiving it. And you showing it to me now does not refresh any memories from May 10th of 2023.
All right, I will move on.
I'd ask the court to admonish the panel to disregard that item.
Well, I'll instruct the panel. I will not admonish the panel. The panel will be instructed not to recall anything with respect to what they may or may not have seen with that exhibit.
And admonishment is probably the wrong word. Thank you.
Admonishment is a pretty strong word, it's true. Christina Rauenhorst applied for the court administrator position about the same time as Jennifer Johnson did. Is that right?
They did apply at the same time.
And you later hired Christina Rauenhorst as a senior legal technician, is that right?
After she interviewed for that position.
She interviewed for the court administrator position?
She interviewed for the court administrator's position, and she interviewed for the senior legal technician position.
Okay. Did you want to hire her as court administrator at the time that you ended up hiring Jennifer?
She was a good candidate, and that she was discussed amongst the panel as one of the options.
Christina Rauenhorst is the current court administrator, is that right?
Yes.
Okay. Would you describe yourself as being at the top of the hierarchy of authority at Bremerton Municipal Court?
As the presiding judge of a one court with the part one half day or 0.5, a little bit under 0.5 commissioner, and a court administrator. So yes, so the way that the court is set up is the presiding judge, our court administrator, our services support specialists, probation department, 2 seniors, 2 legal technicians, 2 legal technicians, 1.
And were
And
you,
then we have security staff that is on contract, 2 different contracts for armed security and merchant services for screening security.
and was the list you just read kind of in order of authority? So yourself and then the court administrator and so on. Was that in descending order of authority?
That is the current setup of the court. Yes, as far as the flow chart and how things flow and the organization, no chart. While, but as a part of this, because of the city government above me, and because it's a city court, is the mayor and the city council.
In your direct exam, you referenced GR 29. Did you mean General Rule 29?
Yes.
And that rule says that the presiding judge has authority over the court employees. Is that right?
I believe if we're just summarizing that that says the presiding is responsible for all things under the court, I think except for salaries.
Okay.
But in essence, I believe overall, my reference was all things.
Okay. So you're bound by GR 29.
Yes.
That's a source of your authority, GR 29.
Yes, and all other general rules and codes and RCWs. So yes.
Okay. You have a pending legal action against the city of Bremerton alleging that they owe you back pay. Is that right?
My pending legal action against the city of Bremerton is in regards to my pay.
Is it your
that my
contention?
pay has not been raised since 2022, that the city of Bremerton was a part of the court improvements grant plan, and that a part of that plan was that elected judges' salaries that were part of that program be paid in conjunction with the judges' salary commission, and that at a minimum it be 95% of a district and superior court judge's salary.
Okay. And one of your claims in that lawsuit is that you should receive back pay. Is that right?
I cannot say if that is a specific claim, but ultimately, I believe that it's inferred that if I have not received pay increase since 2022, because the city council tabled my pay and told me that they could reduce my pay to $80,000 if they wanted to, then that is a part of the claim.
Okay. Have you ever been accused of contributing to a hostile work environment in an organization?
Section like a foundation form of the question, I think, and calls for a legal conclusion as to hostile work environment, which is generally based on, well, I'm not getting into any other details. I think it needs to be defined if the question is going to be asked.
Overruled.
I'm waiting for a question.
There's a question pending, Judge Flood.
I think you should repeat it because I didn't hear it with the objection and the fuss. So sorry. Would you please repeat the question so that I can answer?
Sure. Have you ever been accused of contributing to a hostile work environment in an organization?
Don't know what you're referring to.
In 2021, while you were the president of the board of directors of Kitsap Community Resources, their leadership team accused you of creating a hostile work environment for staff. Isn't that right?
Objection beyond the scope, lack of foundation, assumes facts. Counsel's testifying.
Overruled.
I again don't. I do not believe that is correct.
Were you president of the board of directors of Kitsap Community Resources in 2021?
Yes, it was.
Is it your testimony that the leadership team of Kitsap Community Resources did not write to the board of directors accusing you of a hostile work environment for staff?
Objection assumes facts, asked and answered. Beyond the scope of direct.
Overruled.
I'm sorry, I didn't hear you, Judge.
I said overruled.
My testimony is that I do not believe your statement is true. That as to what you're saying there, I believe that there was information sent to the board through another source.
Let's take a look at this document for a second. I'm sharing what has been identified as Disciplinary Council's Exhibit 219. Judge Flood, have you seen this document before?
Not in this format.
Was Irmgard Davis a person who was affiliated with Kitsap Community Resources when you were the board president?
I object and ask to have this taken down. It's all hearsay. It's beyond the scope. It's not relevant to these proceedings. She's just shown the whole thing to the panel.
I'll instruct the panel appropriately at this point. You continue to ask your questions, Ms. Rasnick. Overrule the objection.
So the question, Judge Flood, was Irmgard Davis, whose signature is right here, affiliated with Kitsap Community Resources when you were the board president?
Yes.
And in this letter, Irmgard Davis and the other signatories are accusing you as board president of creating a hostile work environment for staff,
Your Honor,
bullying and intimidation tactics.
Wait a minute.
Is that what the letter says?
I object. It's hearsay. It shouldn't be shown.
This is impeachment.
Your Honor, I'm sorry, still speaking. This going through and reading from it when it's not an admitted exhibit is my first objection. Second, is it's not proper impeachment in this case. Third, it's beyond the scope of direct examination. But you can't just start reading from a document that isn't even in evidence. Yet there it is right in front of the panel.
Okay. First, given the breadth of statements made during direct, this is, in my view, a fair impeachment. Secondly, it is impeachment. And so narrowly, Ms. Rasnick, and this goes to you, you're only going to appoint or reference statements that are impeaching. And this one that you have read is impeaching. Beyond that, I don't want you to go further than that. And I do want you to limit the amount of exposure this document has to the panel. I am going to appropriately instruct the panel regarding its use as impeachment, not as substantive evidence. But I want you to be, there is some merit to having this document up for an unduly lengthy period of time, or to read from it for purposes that go beyond the narrow impeachment that you're trying to use it for. With that, let's continue the questioning, but please be direct and appropriate and efficient.
Judge Flood, do you see the first sentence on the page that's displayed right now, indicating that the signatories of the letter are accusing you of creating a hostile work environment for staff through bullying and intimidation tactics? It goes on to list such as cutting off staff mid-sentence during presentations and discussions, discussing personal opinions of a management member with other staff members, lack of communication regarding meetings, in-person visits and information directly affecting staff members, singling out staff members for unprofessional and degrading discussion, setting expectations for staff members not consistent with her position, e.g. expecting a staff member to respond to a demand or request from her, thus violating bylaws. Do you see that bullet point?
I have said in my testimony that I have not seen this letter in the way that it's being presented here. When I was running for judge in 2021, and this letter references when I was running for judge, this letter came out during that campaign that this was going on. In the way that you're reading it and the way that it's being presented, and it was put in the paper. The way that it was presented to me as board president was through the Kitsap Community Resources attorney, who had basically, the best way to put it is, put out a letter to the board representing the staff against the board pertaining to the hiring committee for the new executive director, which I was elected and nominated to lead the hiring committee panel. This letter references that hiring committee panel. So when I say that I did not, and I'm not familiar with this letter in this setting, in this format, that is what I'm explaining to you, that this was put in the Bremerton Sun. It did not come to the board in this format.
So you saw this letter in the Bremerton Sun?
Yes.
Okay.
Oh, I apologize. It's not the Bremerton Sun. I've been around 30 plus years. It was the Bremerton Sun. It was the, you're not understand what it's the Kitsap.
It's the Kitsap Sun.
Yes, so
I do that too. Yes.
Ms. Rasnick, you're not offering that exhibit.
I am not offering that exhibit. That exhibit is for impeachment. To the extent that the panel is being provided with exhibits that have been used for impeachment, I would like them to see that exhibit as well. But I'm not offering it as substantive evidence.
I would object to it being shown to the panel as impeachment, Your Honor.
Well, at this point, the panel has seen it with respect to impeachment. And I will instruct the panel that that letter is not substantive evidence. It's not admitted as substantive evidence. You shall not consider it as substantive evidence as to the truth of the statements made within the letter. It was used for impeachment, which is an appropriate use of that letter. All right, go ahead, Ms. Resnick. Ms. Razzak, maybe I can ask you at this moment where you are. We're rapidly hitting the 90-minute mark of your cross-examination, and I'd like to get a sense of your timing.
I am almost done.
Okay, please proceed.
I am almost done. Judge Flood, your deposition in this case was originally ordered set for November 6, 2023. Is that right?
I don't recall specifically.
Do you recall your deposition being ordered set and then being ordered set for a different date?
I don't recall specifically.
Do you recall your deposition being set to occur on January 10th if counsel didn't agree to another date?
I know there was a few dates, but I again, I don't recall specifically. I remember there being a lot of dates and scheduling issues, but and then
Do you recall your deposition starting on February 7th?
I object beyond the scope, 403 relevance.
Overruled.
Do you recall your deposition being started on February 7th?
I do not recall the specific dates. Okay. I do remember it was sometime in February.
Do you recall? Sorry about that. I didn't mean to speak over you. Do you recall your attorney, Vonda Sargent, suspending the deposition after about 20 minutes?
I object to this, same basis.
Overruled.
I remember there was a back and forth between you and my attorney, Vonda Sargent, at the time, that there was an inquiry made into the people who were in attendance and if everyone who was in attendance should be there. I remember there was a back and forth about the questions that you were asking, similar to these proceedings now, objections being made. And the purpose of the deposition and me being ordered to testify and give testimony against myself. She wanted to make a record. You wanted to make a record. There was a back and forth. So I don't know if that was more than 20 minutes, less than 20 minutes. It seemed like a lot of there was a lot of back and forth in my opinion. So
do you recall your attorney, Vonda Sargent, then moving for an order claiming that you shouldn't be deposed at all?
Objection, foundation, calls for hearsay. Relevance.
Ms. Rasnick, a lot of this information is already in the record. Where are you going with this?
Sure. One of the factors that the panel is going to have to consider to determine sanction is the respondent's compliance or lack thereof with this proceeding. And I have just a few questions to ask the respondent about this proceeding and her participation in it.
Ms. Bremner?
Your Honor, plus we weren't even part of that, so that's another layer of objection. But I don't think what the lawyer did at the time should be used with respect to the issue that's just been stated by counsel on cooperation.
With that, I'm going to overrule the objection. Go ahead.
Judge Flood, do you recall your attorney moving for a protective order so that you would not be deposed at all?
I recall several motions being made about these proceedings and being able to defend against these proceedings while defending against the proceedings, being accused of not being cooperative in the proceedings. That's what I remember.
Do you recall that the disciplinary hearing was previously set to begin on March 18th, 2024?
I remember the disciplinary proceedings were supposed to start in November of 2023.
You don't recall
I-
an order
I-
setting the proceedings to happen beginning March 18th, 2024?
These proceedings have been continued and been around for a while. My remembering in that is that they were originally set for November of 2023, or the fall of 2023, or 2022. But I remember that there's been several notices regarding panels being changed. So there's been several notices. Believe then it was set again, and that it was set in March of this year. So
Of
I
20
believe this has been set more than one time.
Do you recall your attorney asking to delay the March hearing based on,
Objection is beyond the scope, hearsay.
Overruled.
do you recall your attorney asking to delay the March hearing based on your medical condition?
I recall that I would not be available for one of the hearing dates for a medical appointment.
Do you recall
And
that I'm sorry, Judge Flood, your name is appearing over your mouth in
Oh,
the way I'm seeing you, so I cannot see when you have finished speaking.
okay. Can you, it's just,
That's better, thank you.
okay,
Or if you could
sorry,
sit up a little bit.
I'm a little,
I
it's
understand.
it's a big chair, sorry. And I'm trying to sit up there. So the,
I think I needed to ask another question.
okay.
I think you finished asking the
Okay.
question. At the time that your attorney asked to delay the hearing based on your medical condition, your attorney didn't provide any documents to substantiate the medical condition. Is that right?
Objection calls for hearsay. Relevance is beyond the scope, and her medical condition is not at issue in this case. And privacy, HIPAA.
I can't think it's hearsay, but at this point, Ms. Rasnick, this is part of the record in this case. Unless you've got something that goes beyond what's already in the record in this case and amply documented in multiple orders. Perhaps there's an angle here with Judge Flood that you're trying to get at that I don't understand, but be efficient. I'm going to overrule the objection, but again, I don't know that you need to trod ground that's amply in exhibits in the orders.
All right. Judge Flood, you were ordered on several occasions to provide information about your medical condition. Is that right?
I was ordered to give updates on several things.
Some orders were entered reflecting that you had not complied with the orders to disclose the medical information. Is that right?
I don't remember every specific order of the presiding here. The judge asked me to do some updates. I provided those updates. Council did not see my updates as sufficient. Council then wanted to obtain my medical records through subpoena. The VA hospital said that that wasn't going to happen. I provided the documentation to support the information that I had available to me at each junction that I was told to do. I provided what I could when I could provide it at those times. And in my opinion, it was sufficient. In your opinion, it was not. The judge ruled and did not do a subpoena in the end. It was also put in the newspaper that I was not cooperating. All of the information was sent to the Kitsap Sun again, that the judge was ordered to do something and she was not complying.
And you told the
It's
kids, you
never
told the
enough.
Kitsap Sun in August 2024 that you never said anything about a medical condition to the
Objection.
commission. Is that right?
Objection, hearsay.
Overruled.
I'm sorry, I'm not understanding your question.
You just mentioned that the Kitsap Sun had covered the issue of the delay in the proceedings because of the medical condition. You mentioned this, that it came up in the Kitsap Sun. I'm asking, you told the Kitsap Sun in August 2024 that you had never said anything about a medical condition.
I never told the Kitsap Sun that they put in the paper what they wanted to put in the paper. My declarations and sworn declarations to the court is what my statements were and what I provided. Whoever the court reporter was, they pick and choose what they want to put in the paper. Whatever sells headlines is what is put in the paper. And again, as I said, that this has been a public lynching. The whole thing, even with the Kitsap Community Resources letter, and as president of the board, there was an independent investigation with 19 witnesses. I was given an award at the end of my term. I finished my term. So all of these allegations that came forth that was put in a paper when I was running was not proven. And none of that was published. But the attack on the eve of the election was. And the people in my community, the people who have worked with me outside of those individuals at KCR, and everybody knows KCR has had a reputation in our community to be an institution that has had issues. They had an issue with the person who was selected as the executive director being a Black man. That was their issue with me. The issue with me was that I put together an independent hiring committee from the community because it's Kitsap Community Resources. The hiring committee needed to be representative of the community for this leadership position.
Just have a couple more questions. Judge Flood, earlier,
A moment, please.
of course. Sorry, Your Honor, I'm not sure what has happened. I don't see Judge Flood on camera.
Your Honor, she's taking a second and composing herself.
Just for the record, she appeared to be very upset and turned off her camera and said something like, "I need a moment," or something like that.
All right, appears that or rather Judge Flood is back with us. Ms. Rasnick.
All right. Judge Flood, earlier today, I believe it was today, you testified that you were handling a matter on the record in Bremerton Municipal Court this past Monday, October 21st, from 8 a.m. until about 8:27 a.m. Is that right?
Wasn't it Wednesday?
No, that would have been Monday, October 21st.
I was on the record in my court for our video and custody calendar on Monday at 8 o'clock. And I gave the reasons why.
You testified earlier that you were handling an order for a therapeutic court participant. I just want to make sure I'm tracking that. Is that correct?
When I came on the record, I asked the jail to please bring Mr. Sampson in because he was not there and he is the therapeutic court participant who I wanted to have heard.
Thank you. But a court commissioner was available who could have signed that order regarding Mr. Sampson, right?
Sims facts, objection.
Overruled.
A court commissioner could not have handled the order the way that it needed to be handled, as all the matters dealing with our therapeutic court committee and participants, there's additional details how the orders have been handled. And so she did not have that information, and I did not have all of that information until that morning.
And when you logged on to the hearing about 8:40, you said you had not had an opportunity to review the proposed stipulation. Is that right?
Objection, this is all beyond the scope, Your Honor, and counsel's testifying as to the time.
Overruled.
I said that the stipulation, as I recall, had not come in to me before 8 o'clock. So the stipulation came in from my review of my emails after and while I was logging in to the proceedings that was set to start at 8:30.
Do you recall that we had been instructed to log in at 8 a.m.?
I do not recall.
That's all I have on cross, Your Honor.
No questions, Your Honor.
Ms. Rasnick, and thank you, Ms. Bremner. Ladies and gentlemen of the panel, you now have an opportunity to ask Judge Flood. Commissioner Moody has a question. Commissioner Moody?
Thank you, Judge Price. Judge Flood, good afternoon.
Good afternoon.
There was a point where you were notified by the CJC formally of the complaints. I'm not talking about when you testified that an attorney said it to you in court. I'm not talking about that date, but when you were formally notified. Have you changed since then your courtroom demeanor, and have you changed the way you deal with your team, with your staff since that notification? And if you have, how? Thank you.
Thank you. I believe so. I've tried to do more trainings. I brought in, one of the things that I did was I brought in a speaker that we had at our judicial conference who talked about stress and protein and being healthy and eating, and how that stress can be in the workplace. And I have brought in, and this was in the most recently in the last month, a complex trainer who spent an afternoon with us one-on-one, and some of the staff remarked that they felt that was one of the best trainings that they had attended, and it was for the entire staff, because they're I wanted to make sure that I'm being conscious of workplace stressors, and that there can be so many contributing factors. We have a protein bar program where we give out protein bars for those who come into court, because sometimes people are upset and defendants are upset. They haven't eaten. And so there can be many different factors. So I have tried to do that. I just recently finished a change management course with eCornell just this past week to taking classes with making change, leadership change styles, and how as far as communication styles as well. And that was one of the, I think, key things is understanding that communications by individuals, some people communicate better in writing, some people communicate better in person, over the phone, pictures. Some people like to draw, as far as communications, but understanding different communication styles. And I think a significant change has been since the I believe it was the current court administrator who mentioned Mr. Teet's incident with the staff. And being able to understand frustrations of counsel and parties, because we do have a difficult platform to navigate that. And sometimes things don't work as far as our platforms, as far as our IT, but also understanding that we can work together to get it done. And an example would be this week, Tuesday. All of our systems, our platform was down. And IT, because it's based on the city's schedule, they don't understand that we start at 7:45. So we didn't have any IT systems to have court that started at 7:45 on Tuesday. But we were able to, and we had a public defender who's at the jail. Everyone's on Zoom. So we have Zoom, but we didn't have any of our systems that the prosecutors could see, that I could see. And then just being able to slow things down and sometimes clear communications so that when I am slowing things down, that they understand why. But also, I think there's grace on both sides. The longer period in time in which you allow for a relationship to develop, the more you can understand a person's style and how things are done. And that's a part of the Making Change program that I recently did, but also being sensitive to and acknowledging here that I may not be immediately aware of a person's feelings, but I need for that to be said to me and saying that. And I believe that, I don't know if I can reference declarations, but I believe I have 2 of my current employees that have written declarations in support of me. I believe that as a new judge, I'm not trying to make any excuses, but I don't feel that I've been given the opportunity. It's easy to say to a person, did you hear that? Did you see that? To get buy-in, and then that buy-in to go on and on and on and become another story. But I believe that now we have been able to grow beyond that. I was a little surprised to hear that some of the things as far as my current court administrator, because we were just in June at the court administrators and presiding judges training. And we had been talking about Facebook we've had some communications on things to do in the future. So I do believe that changes have been made.
All right, thank you. With respect to follow up narrowly on that one question, I do see we have other hands up from our from commissioners. So Ms. Bremner, any follow up narrowly on that answer?
Only this, thank you, Your Honor. And do you want to continue to be trained and improve?
Yes, and I have done several things to get information and to get training. Like I said, recognizing that this image and of me as a Black woman, that there's lies, that bringing in support from the state, bringing in support from the county. And I brought in Judge Hemstreet to sit with us and talk with our community court program. And then we're scheduled to meet next Tuesday as a group with the city attorney, all of our community partners, and I have a community court, drug court speaker coming for that. So, and we're scheduled for that next Tuesday.
Thank you. Thank you, Judge Flood. That's all I have on this question, Your Honor. Thank you.
Ms. Bremner, Ms. Rasnick, anything from you?
Nothing on this question. Thank you.
All right, thank you. Commissioner Miller has her hand up. Commissioner Miller.
She's
Hi, Judge Flood.
Hello.
I'm not sure if my questions are supposed to be limited to just the direct and the cross-examination of Judge Flood. Can I ask am I okay to ask any question?
You are okay to ask any question. Both counsel have the opportunity to object to the question, and they may do so, but you may ask your question.
Okay. How much of the pushback that you got when you entered the court do you think could be attributed to COVID protocols that people may or may not have agreed with? How much do you think that contributed to?
Uh-oh. I can't hear her.
Sorry.
you
Oh.
muted. Yeah.
Sorry, it's my touchpad is sensitive. How much of that do you think contributed to this it escalating to a commission hearing?
I believe it was a big impact because initially I believe when I met with after the election, because it's a one court bench, there's the immediate swearing in by Supreme Court Justice with single court judge benches because day one, you're having to go in, and COVID was still rampant. Of course, we had vaccinations. Bremerton Municipal Court had not had any jury trials, so there was a backlog that existed from that. A lot of hearings were being continued and continued and continued. But even more so, I had facilities and maintenance come in and put up partitions in the courtroom because there was not any. So I put in a lot of COVID things that were not there when I arrived. And I instituted a mask mandate for the entire year. I did not lift the mask mandate to the end of the year. So I believe that frustrated a lot of people and didn't make a direct but indirect impact from my knowledge in Luann, who had been there, moving to Oregon, was her husband had worked at the shipyard and didn't want to comply with the vaccine policies of the shipyard. So they moved out of state. So that was one of the employees who there was an impact on the court early on. And also the employees attended Judge Doctor's retirement and COVID. A lot of people got COVID from attending that retirement party, and I had to enter orders to close. So there was a lot of impact.
Thank you, Commissioner Miller. Ms. Bremner?
No follow-up. Thank you, Your Honor.
Ms. Rasnick?
Just briefly, Your Honor, I think you testified that the mask mandate was only through the end of the year. Would that have been through the end of 2022?
I believe I kept it in place for a year with the mask mandate because it was longer than the city. So I'm sorry, I can't be exact, but I know it was longer than the cities because we had machines that took temperatures and around the city, and we had a machine that we had in place longer than the rest of the city departments.
But that particular COVID protocol, that's been over for more than a year now, right?
The mask mandate was for about a year, maybe a little bit longer.
Okay.
And I'm sorry.
But if you took the bench in January 2022, the mask mandate was over by the beginning part of 2023.
With
correct?
The exception of you have to wear a mask if you have any symptoms. So
Correct.
I still have a mask. The policy is that if you have any symptoms, any type of cold symptoms, you have to wear a mask in the courtroom or be in the in our Zoom room.
Okay, thank you. Nothing further on
Thank
this
you.
question.
Ms. Bremner?
Nothing further. Thank you, Your Honor.
Thank you. Looks like we have a question from Commissioner Schley. Commissioner?
Yeah, I just want a point of clarification on the statement, on the stipulation of facts on the code violation. It was stated that only 2 staff members came to the swearing-in ceremony for Judge Floyd. And later on, I saw that actually, 6 staff members attended. And I was wondering if I could get clarification. How many actual members were there in support of you're swearing in? Staff members, yeah.
So my belief, and that's why the stipulation says 2, is that the 2 were Don and Heather, and that they were sitting in the back. I believe another person said that he was, Mr. Cohen said he was there, and he believed that the others were not available. But my belief is that there were 2. I do not recall or remember seeing Mr. Cohen at my swearing in.
Right, Ms. Bremner,
No follow-up. Thank you, Your Honor.
Ms. Rasnick.
Judge Flood, do you recall Ian Cohen testifying that there were at least 4 of his colleagues who sat in the atrium in the overflow space?
Objection, counsel's testifying.
I do,
Overruled.
I do not recall or remember anyone other than Heather Hunt and Don Williams sitting in the atrium.
But do you recall
I'm sorry.
do you recall Mr. Cohen testifying that there were some other people, I think he said 4 other people, including himself, who sat in the atrium?
Objection, she's answered this.
Overruled.
I believe he said he remembered or thought that.
Thank you.
Ms. Bremner,
No follow-up, Your Honor. Thank you.
any other questions from the panel? Questions from the panel? All right, seeing none, that will complete the testimony of the respondent, Judge Flood. Judge Flood, thank you for your testimony. So let us talk schedule. The time is now 2:47. Ms. Rasnick, you had said you wanted an opportunity to reflect on whether you were going to propose a rebuttal witness, and you were going to try to reflect about you wanted time to consider that question. You also wanted time with respect to your closing arguments. I have in my head anyway rough estimates of what the parties have given me in terms of their closing argument estimations. But let me turn to you first, Ms. Rasnick. Where are you currently with respect to what you want to see happen?
I don't think I'm not going to have a rebuttal witness. I think we need to go ahead and conclude.
Okay, what do you see your closing argument in a duration?
I would say probably less than a half hour, but I do need a few minutes to finish pulling it together.
Okay, and Ms. Bremner, what do you see in terms of your closing duration?
Your Honor, it may be half hour to 45 minutes, but it may be dependent upon counsel's closing. But I would put it to a half hour, 45 minutes.
So I don't know, maybe we're in that universe in which we don't need to go to Monday.
I know, I was just thinking the same thing.
Referenced by Ms. Bremner. Ms. Rasnick, do you see us completing closings this evening or this afternoon rather?
I suppose we could. It does seem within the realm of possible. Yes.
Ms. Bremner?
Well, I should probably take back what I said about the universe yesterday, but I wouldn't guarantee it. But I would strive to get it done. But if there's, well, Your Honor, you were thinking till 4:30 tonight or 5?
No, my preference, and I have not, of course, consulted with the panel. The panel is aware that have previously scheduled kind of 5:30-ish.
Uh-huh.
I guess I could get a show of hands if people think that's if they have a conflict with that, but my preference would be to stay until we're done. My preference is not to have both counsel promise me 45 minutes and then have them take 2 hours, and then that staying till we're done goes appreciably past 5:30. That is not what I want to see have happen. My proposal is that we take a 15-minute break at this time. Ms. Rasnick can gather her thoughts in 15 minutes. And then we resume with disciplinary counsel's closing argument. We go to Ms. Bremner for her closing, and then whatever rebuttal closing is it remains, and we get it all done by 5:30. Ms. Rasnick, is that realistic?
I would prefer to have say 25 minutes just because I've been on this hearing all day and do not have a team to prepare this for me or with me. So I have been doing the best I can, but would like to have perhaps 25 minutes rather than 15 to pull the last bits together.
Ms. Bremner, what's your take on whether that's realistic?
I don't know if it's realistic time-wise. I mean, I don't object if she wants some more time to get ready, but if you want us done by 5:30, that's just a consideration in terms of 25 minutes versus 15 minutes. But if she needs the time, she needs the time.
Can I get a show of hands from any panel members that has a difficulty going to 5:30 or slightly past? Is there a hand? Commissioner Evans, do you have a deadline?
I have a wedding. Two people are coming in at 5 o'clock for a wedding, and our doors close at 5, and so they arrive, and then so I'm concerned about that. I don't know them. They simply scheduled, and they'll be arriving and ready to go at 5.
Do you have a capable colleague who might be able to substitute for you with a share of the portion of the tip?
There's 5 members on the bench. There's one other member that may be available, and I can check with her.
Okay. Commissioner Schley, did you have an issue? Okay, let's do this. Let us take a break until 3:15. That's not quite what Ms. Rasnick wants, but it's also slightly more than 15 minutes. Let us break now until 3:15, and let's see what we can do to complete this process by this evening. And Commissioner Evans, perhaps you can work your magic and free yourself up until that time. We'll be in recess till 3:15.
Thank you.
Your Honor, I have a question. Oh, poop, all gone. You were considering, fuck,
Oh, you're on.
oops, sorry. You were considering cautioning counsel that they might have to avoid subjects that had been
Let's deal with that
objected
when
to
we-
during the declaration.
We'll deal with that when we come back at 3:15. We're in
Okay.
recess. All right, good afternoon, everyone. Again, it's now 3:15. And looks like we have all the commissioners. And Commissioner Schley, I think you didn't mute yourself after your question. So maybe you want to, there you go. Excellent. All right, my first question is to Commissioner Evans. Did you manage success in freeing yourself up at 5 o'clock?
I think we've got a plan. We're okay till 5:30.
Excellent. All right. So, Ms. Rasnick, let me ask you, after your break here, are you prepared to go forward with closings at this point?
Oh, I will even turn the mic on. Yes, I am. I am prepared.
All right, Ms. Bremner, same to you. You ready to go forward?
I'm ready, Your Honor. Thank you.
All right.
Your Honor, very briefly, I just want to mention that we sent in the corrected exhibit, and I don't think it needs to be addressed on the record. I just want to confirm that.
Okay, I do believe I made a provisional ruling with respect to the exhibit, so long as Ms. Rasnick confirmed it was the correct exhibit. I have made the decision to admit that. Ms. Rasnick, you confirmed it's accurate?
We're talking about the audio.
Yes.
Yes, yeah, the clipped, the modified exhibit is fine.
Is
Thank
it
you.
designated as Exhibit 340B?
Yes,
Okay, excellent.
thank you.
And then one reminder, just before we, well, just after we went on recess, Ms. Kallner was reminding me of something that I had mentioned earlier, which is both councils should be aware the court has, well, the presiding officer has not made final decisions with respect to the objections to portions of the declaration. So I'm going to ask that you not refer to specific challenged portions of the declarations in your closings. Acceptable, Ms. Rasnick?
Yes.
Ms. Bremner?
That's fine, Your Honor.
Okay. All right. Ladies and gentlemen of the panel, please give your attention to Ms. Rasnick, who will provide her first round of closing arguments on behalf of the CJC as disciplinary counsel. Ms. Rasnick?
Thank you, Your Honor. Good afternoon, members of the panel, and thank you very much for your kind and patient attention over the last week, over these 4 days. It's a lot to sum up. We have seen that this proceeding started by the judge stipulating to some violations of the Code of Judicial Conduct. She has stipulated to violations of Rule 1.1, 1.2, and 2.8b. I will come back to those a little bit later. The panel heard from a number of live witnesses this week, and we'll also have the opportunity to receive some witness testimony by declaration. In reviewing my notes, it is notable that virtually every witness called by the commission has testified about Judge Flood's inappropriate treatment of staff and attorneys, its frequency and consistency, and the impact of that behavior on Bremerton Municipal Court. The panel will hear by declaration from Dawn Williams, who had been with the court system for 27 years, including 11 years as court administrator in Bremerton Municipal Court, and she planned to stay in that position through retirement. The panel heard Trish Kinlow and Jennifer Johnson, who were both very experienced court administrators, testify about how they knew Ms. Williams as the administrator at Bremerton Municipal Court and remarked on this as they headed over to Bremerton to help Judge Flood in fall of 2022. Ms. Williams talks about how it became increasingly difficult for her in the 6 months or so after Judge Flood took the bench in January 2022. In her experience, Judge Flood treated staff, longtime staff, including herself and others, like they didn't know what they were doing. She changed court processes that had been in place for a long time, routine things, how bond forfeitures are handled, how probationers are monitored, without explanation. When she was asked to clarify her instructions, she would respond, "That's not what I said," even if Dawn had written the instructions down. There was no acceptance of responsibility. It was always someone else's fault, not Judge Flood's fault. The judge wouldn't listen when Dawn tried to explain to her that the changes she was making in the court processes would put the court at odds with not just procedures, but requirements, legal requirements in terms of the bond forfeiture process. Ms. Williams says the judge would shut me down. She used a mocking, scolding tone of voice as though talking to a child. She talks about how she cried in her car on the way home from work and that her husband told her that the way she was acting was changing. She felt like she was walking on eggshells. A lot of times in the judge's office, Ms. Williams just wouldn't say anything. And she would have her coworker ask the judge questions because her coworker wasn't on the judge's bad side. The panel also heard live from Ian Cohen, who was the court's longtime probation officer. He had been there for 20 plus years in a position he had created, basically. He had to build that position from the ground up and had put all the systems in place. Mr. Cohen broke into tears more than once while he was describing his experiences with the judge and how he felt so bullied and inadequate. The panel heard live from Jennifer Johnson, another very experienced court administrator whom Judge Flood hired as her court administrator to replace Ms. Williams after Ms. Johnson began serving Bremerton Municipal Court through Courts Helping Courts, even though she was employed full-time at another court as court administrator at Des Moines. Judge Flood testified today it is the judge's job to hire a court administrator, and Judge Flood herself points to GR 29, which gives the presiding judge broad authority over a court and its staff. Ms. Johnson, you will recall, described, sometimes in tears, what she endured when she was working as court administrator. She described how she was shocked by Judge Flood's treatment of other staff. Ms. Johnson testified that she had never seen a judge talk to staff the way that Judge Flood talked to Amber Dodge, who was a legal technician. Ms. Johnson testified about how she became increasingly frustrated by the judge's micromanagement of her in her position as court administrator, even though Ms. Johnson had uprooted her family to move to Bremerton when she took the court administrator position. She talked about how excited she was about the position, how she loves to fix courts. She loves to fix systems. She was enthusiastic about helping Judge Flood. Ms. Johnson is Black and Mexicana and was excited about working with a Black woman judge. She had lost hope within about 8 months that there could be any productive relationship, working relationship between herself and Judge Flood, and she resigned. Second court administrator to have resigned. Dawn Williams also had resigned. Dawn resigned and took a pay cut, forfeited leave. Jennifer Johnson went into a completely different part of the court system to work. The court also heard live, or we'll hear by testimony by declaration from Serena Daigle, another person Judge Flood hired who had extensive court experience. Ms. Daigle also began serving the court through the Courts Helping Courts program. She also talks about how she was eager to help out. She was glad to contribute her service. And then her friend, Ms. Johnson, her coworker, former coworker, Ms. Johnson, encouraged her to apply, and she was hired. Hoped to advance to have a position higher in the administration in Bremerton Municipal Court. Ms. Daigle also describes how she was scolded by the judge on her first day, and then the judge's reaction the next week to Serena remarking when she was trying to cover Courtroom for the first time in a long time that she might need to ask some clarifying questions of the judge about the judge's rulings from the bench because Ms. Daigle has a disability. She described how the judge's response was to leave the bench with her jaw clenched, looking angry at Ms. Daigle. And this was after the judge had told Ms. Daigle that she needed to turn off the courtroom recorder before Ms. Daigle asked questions because all the communication between the judge and the staff had to be off the record. Ms. Daigle talked about how the judge snapped at her for not completing orders the way she wanted, even when the judge hadn't told her to do it. She talked about how she had to work more than 8-hour days and how on a couple of occasions she apologized to other staff members about how the judge treated them because she felt so terrible about it. Ms. Daigle states, the exhaustion, gaslighting, and harassment took such a toll on my mental health that I started having thoughts of harming myself. She took leave at the recommendation of her physician, and then she resigned. The panel heard extensively from the Bremerton City Prosecutor, Gary Hersey. who testified about the judge's treatment of the attorneys in his office, both on the record and off the record, and the judge's treatment of public defenders. He testified about the therapeutic court staffings and the judge's treatment of participants from his office and the public defender and the court staff at the therapeutic court staffings, and how the judge's demeanor at those staffings grew more and more hostile as this hearing drew closer. Mr. Hersey also testified at length about the impact of the staff turnover at the court, which has been the hallmark of Judge Flood's administration, on the court's ability to carry out core functions and to continue to do the business of the public. Mr. Hersey, the panel will remember, got pretty emotional a couple of times, talking about the impact on members of the Bremerton community who he described of the court's failure to execute basic functions. And I will come back to that in a second. The court also will receive, or the panel will receive also, declaration from Jacob Murphy, public defender in Bremerton, who also describes the judge's treatment of attorneys from his office and the impact that that treatment is having on his office's ability to continue to retain defenders to serve the public in Bremerton. The panel heard live from Christina Rauenhorst, who is the current court administrator in Bremerton. She testified that she only took the position. She was only willing to become the court administrator, to be promoted into that position, with the understanding that the judge would let her do her job, that the judge would not try to micromanage her. She testified that that agreement she thought she had with the judge is not really working out the way that she hoped it would, that the judge continues to go around her to deal directly with staff on personnel issues that the judge testified should be the court administrator's responsibility, but apparently not when the judge would rather handle the things herself. Ms. Rauenhorst testified about the judge's rude and discourteous treatment of her and her coworkers. She testified about the importance to her of the support that she is getting from other court administrators, from other courts who are helping her to keep Bremerton Municipal Court afloat. And she testified about the workarounds that she has devised with the help of those other court administrators to facilitate meetings with staff from the prosecutor's office to ensure that court business can go forward, despite the judge's insistence on certain practices that Ms. Rauenhorst and others testified really don't make any sense, but they have been told those are the way she wants to do them. All of the witnesses testified about staff turnover. I don't think it's in dispute that all of the staff who were at Bremerton Municipal Court when Judge Flood took the bench in January 2022 have resigned. After that initial wave, the first group of staff hired by Judge Flood have also subsequently resigned. And many of the second wave of staff hired by Judge Flood have also resigned. And resignations continue. Judge Flood is on her third court administrator. Dawn Williams, Jennifer Johnson, Christina Rauenhorst. That is 3 court administrators in the last 2 years. The court administrator, the judge testified today, is the second in the hierarchy under herself at the court. And that position has turned over 3 times since January 2022. Judge Flood is on at least her third probation officer. I kind of lost track of that. After Ian Cohen resigned after his longtime service, I don't know, we didn't really get a clear sense of who did the probation officer's job for a while. Then there was a person named Alexis Oler in the position who also resigned. And now there's someone new. A lot of turnover in a position that has a really key function, not only in the operation of the court, but in protecting the community in Bremerton and monitoring folks who are under conditions that have been imposed by the court, keeping the community safe. That position has turned over at least 3 times. Judge Flood is on her second therapeutic courts coordinator. She's very proud of the work she has done on therapeutic courts. The first person who she hired as therapeutic courts coordinator to set up the program and sort of design the system, he resigned. She's now on her second therapeutic courts coordinator. The experienced courts coordinators who have tried to help Judge Flood, Jennifer Johnson, Latricia Kinlow, Maury Baker, who kind of came out of retirement for some months in 2023 to try to help fill the gaps, to plug the holes in the dike after Jennifer Johnson resigned. Mr. Johnson ultimately decided, or I'm sorry, Mr. Baker ultimately decided that he couldn't keep volunteering. He testified by declaration that he didn't think anything was going to change. Latricia Kinlow, who is currently the court administrator in Tukwila Municipal Court, who continues to be a resource for Christina Rauenhorst, testified she too had never seen a judge treat court employees like Judge Flood treated, particularly Amber Dodge. She was appalled at the treatment that Judge Flood, that she saw from Judge Flood towards this former employee. And Ms. Dodge, like so many, resigned. Ms. Johnson, who was court administrator, also resigned. The areas of court functioning that are being impacted and have been impacted by the turnover of staff include, and we heard so much about this, calendaring and docketing, monitoring probationers and pretrial diversion agreement compliance, notification of Bremerton Police Department about warrants and warrant quashes, notification of the Department of Licensing about suspensions and IID requests, notification of Washington State Hospital of competency orders and restoration orders, notification of the Bremerton Police Department of no contact orders and rescissions and modifications of no contact orders. Accounting and collections have been a mess. Although Ms. Rauenhorst testified about her efforts to try to get that back online and back in some kind of control with the help of other court administrators. Restitution payments. You heard testimony that restitution payments were not being sent out to victims, although those who were required to pay restitution were making the payments and the money was sitting in the court's account. Exoneration of bail. You heard several witnesses talk about bail bonds that should have been forfeited, should have been exonerated, that were not, and some sat for months and months and months before the backlog was finally cleared because of changes to the process that the judge made that made it much more difficult to exonerate bail. Mr. Hersey particularly talked about impacts to community members because of failures to notify Bremerton Police Department about warrants. Mr. Hersey talked about folks who were subject to arrest that could have been prevented. He talked about folks who were not arrested after apparent violations of conditions, and one particular gentleman who overdosed, who, if the right notifications had happened, might have been arrested and brought into custody and allowed to or enabled to connect with services that could have saved his life. You also heard about issues with the recording of court proceedings. Mr. Hersey talked about how at least a couple of trials have resulted in mistrials because of failures of the recordings. Now, the judge will say that none of these things are her fault and that she's not connected to them at all, and that they all have to do with her staff or someone who is not her. But the judge also testified that she is the person at the top. She's the person with whom the buck stops, according to GR 29 and her own conceptualization of the hierarchy within the office. I would urge the panel to consider that you cannot have it both ways. You cannot be at the top and not accept the responsibilities of being at the top. As I mentioned at the outset, the judge has, on Monday of this week, entered into a stipulation admitting some violations of the rules of judicial conduct. On the first day this hearing was scheduled, after we had actually gone on the record, the stipulation was signed and then was accepted. The judge has admitted her conduct violated Rule 1.1 of the Code of Judicial Conduct, which requires judges to follow the law in court, including the code itself. She has also admitted that she violated Rule 1.2, which requires a judge to act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and to avoid impropriety and the appearance of impropriety. And finally, she has admitted that she violated Rule 2.8b, which requires a judge to be patient, dignified, and courteous to everyone they deal with in an official capacity. Those are the violations she has admitted. There remains a charge of a violation of Rule 2.5a, which was not admitted. I think what you have heard over the last 4 days is evidence that proves by clear and convincing evidence that this judge did violate Rule 2.5a, and that rule requires a judge to, quote, perform the duties of judicial office impartially, competently, and diligently. This panel heard testimony about the impact on court functioning of the staff turnover and of the judge's lack of understanding and appreciation in many instances of the ways the court is supposed to function. There are numerous other states that have disciplined judges whose mistreatment of staff has impacted court operations. In the appendix to the pre-hearing brief, there is a recitation and summary of those cases. Judges have been disciplined in California, in Iowa, in Pennsylvania, in South Dakota, in Indiana for misconduct that had impact on court operations, particularly when treatment of staff has impact on the way the court is able to function. That's not competence. That violates Rule 2.5a. And if the panel reviews the testimony and reviews the declarations it has received, it will conclude that the pattern of conduct that we have seen here violates 2.5a. Once the panel has determined whether there is a violation of 2.5a, and in taking into account the stipulated violations, it needs to move to its consideration of the appropriate consequence for the judge's actions. That is the sanction. The factors that the panel has to take into account are referred to as the Deming factors. Those are the same factors that are discussed in the Judicial Conduct Rules of Procedure Rule 6, and were sat out in a case called In Re Turco. And in that case, the state Supreme Court said the purpose of a sanction is to educate the judiciary, to deter the respondent and other judges, and to reassure the public that judicial misconduct is not permitted or condoned. The sanction imposed for judicial misconduct has to be commensurate. So it has to be gauged in relation to the judge's culpability and has to be sufficient to restore and affirm public confidence in the administration of justice. Now, the Deming factors, with reference to a case involving a judge named Deming, first require the panel to take into account what we call the characteristics of the misconduct. And the first Deming factor is whether the conduct can be thought of as an isolated incident or a pattern. Here, we do not have violations that are isolated. We have violations that began within months after the judge taking the bench and which continue. Witnesses testified about poor treatment of staff and attorneys that started then. The judge has stipulated 2 violations that started then. And witnesses testified that the violations are ongoing. The issues continued even after Judge Flood worked with a coach, a leadership coach of her choice during the confidential proceedings. Even after the statement of charges was filed, the violations continued. This factor weighs in favor of a serious sanction. The next factor is the nature, extent, and frequency of the misconduct. This factor also weighs in favor of a serious sanction. The violations here are frequent and pervasive. We heard a litany from staff, from attorneys, of conduct on the judge's part that violated 2.8b, which she has agreed that she violated. We heard extensive examples of ways that the judge's failure to competently manage the court is impacting the court in violation of 2.5a. It's hard to think of a part of court operations that is not touched by this misconduct. That is how pervasive it is. The next factor is whether the misconduct occurred in or out of the courtroom. This misconduct occurred on the record and off the record, but in the courthouse and in relation to court employees as well as attorneys. This is all misconduct that happened within the courthouse itself. The next factor requires the panel to examine whether or not there was a violation of the oath of office. The commission is not contending that the judge violated her oath of office. The next factor examines the extent to which the acts of misconduct were injurious to others. And most of the testimony that the panel heard this week focused on that factor. As I have said, the panel heard about how the judge's demeanor has fostered and maintained what can generously be described as a toxic atmosphere in the court. Ms. Rauenhorst talked about this. Other current court staff talked about this. Recently departed court staff talked about this. And how people walk on eggshells, how people wear headphones at their desks so no one will bother them, so the judge won't bother them, how people go and sit in their cars. Others who work at the court have been injured by the judge's violations of the rules of judicial conduct. The staff who resigned, we just heard about Dawn Williams, Jennifer Johnson, Serena Daigle, Ian Cohen, Steve DeRozier, who was the first therapeutic court coordinator, and others, including current staff, Ms. Rauenhorst, all echo this. The experienced administrators that the panel heard from, Jennifer Johnson, Latricia Kinlow, Maury Baker by declaration, also have related the injury to the court and to the public that has resulted from the judge's misconduct. Attorneys, including Gary Hersey and Jacob Murphy, also have related the injury to the court and to the public that has resulted from the damage to the court's functioning brought about by the turnover, which resulted from Judge Flood's behavior. The court at this point, I think it is safe to say, I think it is safe to conclude based on the testimony from Mr. Hersey, Ms. Rauenhorst, Mr. Murphy, Ms. Kinlow, the court at this point is continuing to function well in spite of the judge, not because of her. It is functioning well because of the concerted efforts of the staff and the experienced court administrators and attorneys who are assisting staff in holding it together. The next factor asks the panel to examine whether the judge exploited her official capacity to satisfy personal desires. Here, the evidence shows that there has been repeated abuse of the judge's authority. Ms. Rauenhorst, Mr. Hersey particularly testified about the way the judge's treatment of them has changed as this hearing drew closer. Ms. Rauenhorst testified about how the judge's treatment of her got worse after the judge heard that Ms. Rauenhorst had lunch with Jennifer Johnson, who had been the former court administrator, in March of this year, just before this hearing was previously set to occur. Mr. Hersey testified that the judge admonished him off the record in the therapeutic court staffing for cooperating with the Commission on Judicial Conduct. The last factor in this prong of the Deming inquiry is the effect the misconduct has on the integrity of and respect for the judiciary. And here, the judge's actions and the problems at Bremerton Municipal Court have received widespread attention in the press, including the Kitsap Sun, and it is hard to dispute that the atmosphere at the court, the pattern of staff resignations, the damage to the court's functioning, it's hard to overstate how much it has damaged the public's perception of the judiciary. The second part of the Deming factors have to do with the judge's service and demeanor. First, under this consideration is whether the judge acknowledges or recognizes the acts occurred. And here, as I indicated previously, the judge finally stipulated on Monday, October 21st, 4 days ago, that the acts occurred. Previously, she had simply denied all charges. She had responded to the statement of charges with a general denial. And despite the stipulation, we heard today the judge continuing to persist in refusing to take any real responsibility. The panel heard her during her testimony this afternoon repeatedly distinguish between what she had stipulated to and what was true. She has not taken to heart the impact of her actions on her current or former staff. She continues to blame them. She continues to accuse them of being allied against her. She blames the city council. She blames racism in the Bremerton community and among the staff members herself. So even beyond simply acknowledging that the acts occurred finally, it's clear this afternoon from the judge's testimony that she signed her name to a piece of paper acknowledging that the acts occurred, but she has not really taken responsibility. The absence of a commitment to change or modify behavior underscores the need for a heightened sanction. That is what Cynthia Gray wrote on behalf of the American Judicature Society in 2002. A genuine commitment to change and modify behavior is what the panel should be looking for. Here, the judge talks about having been to the Washington Leadership Institute, the Judicial College. She's recently talked about having taken a training focused on empathy, but only in the context of the court's treatment of offenders. No insight into the impact of her behavior. The trainings that the judge has taken do not address the violations that have been agreed to. There is no training that she has received that appears aimed at modifying her behavior, nor is there any indication that she believes modification of her behavior is needed. Second factor, whether the judge has evidenced an effort to change. I spoke about this a little bit a second ago. There's been no real effort to change. The judge has paid lip service to this. She was given the chance to work with a coach during the confidential proceeding. She did that. Nothing changed. She could have worked with that same coach or any other coach at any point during this litigation. She could have sought out different kind of intervention. She could have sought out more behavioral focused coaching. But what we continue to hear about is going to trainings about team building and having protein bars in the courthouse and having a food pantry, all of which is wonderful. No argument that protein bars in the courthouse are not a good thing. But that is not effort to change the behavior that made this proceeding necessary. The next factor is the judge's length of service. She's been on the bench since January 2022. She has known about these problems since then. Judges who have been on the bench for a year or two are just as culpable and are just as bound by the rules of judicial conduct as judges who have been on the bench for longer. And this judge should not get a pass because she's only been on the bench for 2 years. The next factor is prior discipline. There is no prior discipline. That factor is inapplicable. The next factor is a significant factor, which is the judge's cooperation with the proceeding. And here, the lack of cooperation the judge has displayed throughout this proceeding weighs strongly in favor of what I am going to recommend, which is censure with a lengthy period of suspension subject to conditions. We started this proceeding with the judge not timely responding to the statement of charges or providing a meaningful response. She went on to obstruct the scheduling of her deposition. After initially stipulating that the deposition would occur, she then obstructed, refused to cooperate with scheduling it, despite the presiding officer's order that she do so. Her attorney then inappropriately suspended the deposition after only 20 minutes, requiring a second motion from disciplinary counsel and a second order delaying the deposition further. Finally, about a week, I think, before this hearing was scheduled to occur in March of 2024, Judge Flood's attorneys demanded a last-minute continuance of the hearing on the ground that she was experiencing serious and grave health issues which prevented her from appearing. But when she was repeatedly ordered by the presiding officer to provide documentation to substantiate the claimed health issues, the judge failed to comply.
Objection, Your Honor. This court ruled that they need not be released. We filed a motion on this.
I am referring to the orders entered in this matter, requiring the judge to provide regular update submissions.
I'm sorry, the objection is overruled, and at this point, the argument is not straight into sealed issues, but if it does, I'll certainly caution counsel not to get into sealed issues. But at this point,
I'm not going to do that.
I'm overruling the objection.
Thank you.
What I'm referring to are the orders that the judge provide documentation to substantiate the claims that were made by her attorneys back in March as the basis to delay this proceeding. She was ordered to provide monthly or periodic update submissions, which were to include documentation, which was not provided. She was repeatedly reminded of her obligation to provide that documentation, finally requiring a subpoena to be issued. This was after repeated noncompliance with the orders, simply requiring the judge to provide information to substantiate an issue her attorneys had placed into controversy. The judge will claim that this proceeding has been harassing to her, that it has been embarrassing to her, that she has been, that the commission has inquired into private matters, including her health, but her own attorneys placed that issue, opened that issue up by coming in and requesting an 11th hour continuance based on assertions about Judge Flood, which were not substantiated. And then when there was repeated requests for the substantiation, it was not provided, and the request for substantiation was somehow weaponized to cast the whole proceeding as some sort of effort to harass the judge. That is why we are in October of 2024 with this hearing. There has been, it's difficult to find, it's difficult to think of a word to encapsulate the degree of obstruction and lack of cooperation that has characterized the judge's participation. Until Monday, when we finally were able to get a stipulation signed, narrowing the issues somewhat. That was too late. 1 day of compliance does not erase the more than a year of non-compliance which preceded it. Cooperation, the factor of cooperation should weigh strongly in favor of a serious sanction here. The last factor, ethics opinions, doesn't apply. In conclusion, I want to address just a couple of things. One is that respondent is likely going to contend that this case is identical to the Eiler case, which also involved a judge from a court of limited jurisdiction who was discourteous and was sanctioned for being discourteous. Eiler is not controlling here, and it's distinguishable. That case involved a judge who berated pro se litigants, who said horrible and offensive things to pro se litigants. And the misconduct was confined to the judge's conduct towards pro se litigants on the record who appeared in front of her. In Eiler, the panel found violations and recommended a period of suspension. The case went to the Supreme Court, which also found violations. And the divided panel of the Supreme Court concluded that the judge's actions didn't undermine the integrity of the judiciary because she didn't take bribes or show favoritism, and so reduced the period of suspension. The dissent, which was 4 members of the Supreme Court at that point, disagreed. This case is different from Eiler because this pattern of misconduct is more egregious. This is not a judge who simply was a tough old broad to pro se parties who appeared in front of her, who maybe she didn't like because of prejudices that she held. This is not Eiler. This is a judge who was abusive to her court staff, who was inappropriate to attorneys who appeared in front of her, who continues to be abusive to her court staff and inappropriate to attorneys who appear in front of her, and who set in motion by that conduct a series of events at Bremerton Municipal Court, which have impacted the court to a degree that, frankly, it is difficult to imagine what steps are going to be needed to get the court back to a regular level of functioning. This is egregious misconduct that has damaged the court. The second piece I want to address is the likely claim that the reason for this proceeding and the reason that the court is in a state of crisis is because of institutional racism in Bremerton, in the city government, or in the court. I am not going to argue that there is not institutional racism in the court system. I am not going to argue that Judge Flood has not been subject to racism. The stipulation that we signed reflected that the judge has experienced, as a Black woman on the bench, has experienced racism. We stipulated that microaggressions and macroaggressions are dynamics that exist, and it would do no good to pretend that they do not exist. But although they exist, they are not an excuse. They are not a mitigating factor. The judge's experience of racism from whatever source does not diminish her obligation to comply with the Code of Judicial Conduct. She took an oath when she was elected to be a judge to serve the people in a public trust. And there's no escape hatch from the public trust if the judge finds herself burdened by the impact of racism. As I said to start, judges really have uniquely powerful positions in the community. They have an affirmative duty to maintain focus on the business of the court, even in the face of offensive language or behavior directed at them. That was something that the state Supreme Court took up in the Hammermaster case, that judicial independence does not equate to unbridled discretion to bully and threaten. Judges in Washington don't get a pass because of what is happening to them. Judges have a unique set of responsibilities to, at all times, uphold the integrity of the judiciary. That has not happened here. There have been violations of the admitted sections of the code 1.1, 1.2, 2.8b. The panel should also find by clear and convincing evidence a violation of Rule 2.5a. In weighing the Deming factors, it should conclude that the recommendation should be censure with suspension, and the period of suspension should be substantial given the aggravating factors. In view of all of the cases, a period of suspension of at least 6 to 9 months at a minimum. The sanction should include the period of training, coaching, and mentoring subject to commission oversight that is included in the stipulation. The panel might want to consider fashioning more particular requirements and benchmarks that are to be met. But that is the length of suspension that is going to be necessary to uphold the obligation that the commission has to fashion a sanction that will deter misconduct and restore the court and restore the public's faith. That is all I have. Thank you.
Thank you, Ms. Rasnick. So, ladies and gentlemen of the panel, please give your attention to Ms. Bremner, who will now give her closing argument on behalf of her client, the respondent, Judge Flood. Ms. Bremner.
Thank you, Your Honor. And thank you to all members of the commission. I first want to say that you are the Commission on Judicial Conduct, not the Commission on Judicial Administration. I mean, what you've heard here is kind of a litany of complaints of things that are happening in a small court of limited jurisdiction in Bremerton. There isn't misconduct here, and I'll tell you exactly why. And like I said in my opening statement, the Eiler case was my case. And Judge Eiler didn't just belittle pro se litigants or go after certain kinds of people like counsel just said. She was found to have not committed misconduct. And I'm going to read you exactly what the Supreme Court said, reversing this commission. I tried that case for like a month, as I recall it, in front of the full commission panel in King County Superior Court with live witnesses and all of the evidence from commission counsel through Paul Taylor at that time with allegations of severe misconduct. He had argued for removal of the judge. That wasn't granted. There was a smaller suspension. I appealed, and it went to the Supreme Court, and here's what they said. And I want to be very specific in this because this is central and important to consideration in this case. Here's the court. We disagree with the commission, however, regarding Judge Eiler's alleged violations of Canons 1, 2A, and 3A, 4. Judge Eiler's rude, discourteous, and impatient behavior was certainly unprofessional, but it did not go so as far as to undermine the integrity and independence of the judiciary, demonstrate disrespect for the law, or evidence any failure by Judge Eiler to obey it, or to deny any person legally interested in a proceeding of his or her full right to be heard according to the law. And they went on to say, Judge Eiler did not cut deals with litigants behind closed doors, accept bribes, or otherwise demonstrate that her decisions were governed by anything other than the law and the facts of the cases. Her misconduct also did not undercut public perception of judicial integrity or impartiality. She showed no favoritism, prejudice, partiality, or bias. You just heard from counsel about cases from other states, but we're in Washington state. The Eiler case is Washington State Supreme Court with exactly that language. And there was a whole litany about how rude she was and how belittling she was and how difficult she was. And of course, her name was Judge Judy, so it kind of fit in terms of what they're alleging. But this is what the court said. They said that there was not misconduct based on rudeness, being demeaning, or being in any way rude as a judge. Now, you heard about these other cases from other states. Well, there's nothing like that in Washington state. We actually have a list of the Washington cases that have come before this commission, and we have put them together, all of the conduct and demeanor cases, which we will distribute if we haven't already done so. But what we have on conduct and demeanor cases in Washington is there is not one case before this commission, not one case that you've reported a finding on that just dealt with demeanor, tone, personality, and then a finding of misconduct. It's always got to be, like I said in opening, speech plus something. Speech plus being discriminatory based on race, being racist, being bigoted, being discriminatory based upon sexual orientation, immigration status, religious beliefs. And the other cases are things like conduct where a judge drank beer in the courthouse, or the judge said things about comparing someone to the Nazis. Something plus, not just that it's who you are. And I know who Judge Arlo was. I mean, she could be mean. And like I said before, she was mean to me a few times. She also had a very charming side, but they went after her, the commission counsel did, before the commission, on misconduct for her conduct. That was basically what they're alleging here. It's no different. It's the same thing, saying that she's not as cordial as they'd like her to be, or she at times put her hand up, I think, and said, email me. I know I do that all the time. Someone comes to my office, I just say, send me an email, send me a text. I don't even like it if people call me. Depends on what you're in the middle of. She's on the bench all day. And so she's dealing with having to come up for air at times and deal with staff that was trying to undermine her. I did ask her about that quote from Eldridge Cleaver, which is, you're either part of the solution or part of the problem. I mean, I thought his was an interesting choice in terms of a person to quote, because he's with the Black Panthers. But, we haven't really emphasized race in this case where we probably could have and should have, because we want to make sure that we have this case heard on the merits in terms of what was done and what wasn't done. The Judge Eiler case is the only reported decision in our Supreme Court from this commission dealing with conduct, and it's squarely against the commission counsel. It couldn't be more against what she's been urging you to do here. And, really, as a public entity, when you're dealing with a judge that's struggling, that is dealing with all these problems with COVID, that has people in her staff that don't want to work for her, that they're sitting in the lunchroom hoping that she gets thrown off the bench by you, and calling her Tracy and being disrespectful. And as we heard from famous Tyree, he said he'd never seen in 30 years anybody talk back to a judge like that. I mean, imagine if I did this right now to Judge Price. I mean, it's just hard to fathom that it wasn't just staff, clerks, it was lawyers. It was the city attorney. He got up, according to Mr. Famous Tyree, and would push back against the judge all the time. We had that video, or the audio tape with him, where he came out and said that he'd been mistreated and she shut him down and all these different kinds of things. Well, he was summarily impeached by the audio tape, where he kind of squirmed listening to it, because she didn't raise her voice. She didn't chastise him. She didn't do anything that was inappropriate. He struck a jury. He can't do that. I mean, he can't just go in and say, I'm going to grant a continuance. That's what the judge does. You can't just go strike a jury when someone's set for trial. That's what the judge does. And you can't waive the rights of the defendant when you're the prosecutor and say, there's not going to be a trial. There's no jury, and make all of those decisions. All you heard the judge say on that tape was, you can't do that. And he acknowledged that he shouldn't have done it. This is 3 years of alleged misconduct in this case. 3 years. Every single day of court, there's a video, or I keep saying video, audio recording of the proceedings. Every session. The only ones that played an audio in this case were the lawyers for the judge, where we completely impeached one of the main witnesses for the CJC prosecution. So in 3 years of audio tapes, 0 tapes have been played here, none. Don't you think if truly the judge had acted in the way that has been urged upon you, we would have heard at least one? At least one, and we didn't hear any. Look at the Eiler case. They had audio tapes. They had audio tapes of her and the types of things she was saying in court. That's a huge difference. And even with those, there was not misconduct. In the Washington State cases that we're going to have you look at, and I know that you're familiar with your own decisions in the commission, but there's been all kinds of conduct cases, a sexual relationship with a litigant, having financial interests in part of a case, all kinds of things that, again, it's speech plus something. It's conduct that's inappropriate, conduct where a judge is doing something that they shouldn't do. And those cases are admonishments. Earlier in the testimony today, when I used the word admonish, the prosecutor said, well, that's a strong word. It is a strong word. And this judge has agreed and stipulated to be admonished and to take a course of training. She's fully taken responsibility. And she's in a position where she's been through all kinds of turmoil in this case, including, like she called it, a public lynching, where the commission actually puts out the press releases, as you know, of the statement of charges and the like, and makes this a public proceeding. That's what the Kitsap Sun has been reporting on. So she's basically all over the community being painted in a very bad light, and then having to go through these proceedings, and then having prior counsel that had to deal with a number of legal issues that were not of her making. Our presiding judge, Judge Price, had ruled in the medical records issue that there would not be a forced release. So there we have it. The CJC counsel can get up and say, she should do this. She should have given her records. She dragged her feet. Her lawyers stopped the deposition, et cetera, et cetera. Like the judge said, I think very well stated, it's a fine line between defending yourself and cooperating. There is the part of the commission rules that say that thou shalt cooperate. On the other hand, does that mean you just fall on your sword and give up and say I'm guilty and remove me from the bench? Of course not. And so what she's tried to do is everything in her power to cooperate while also legitimately defending herself. I wanted to talk a little bit about 2 of their main quote unquote witnesses. Jennifer Johnson, a star witness. It's like deja vu all over again. The Yogi Berra quote. She had been in another court with Judge Leon, and she'd gotten into some disagreements with that judge. Sounds like, she was always right in her own mind, and she would argue with the judge, and even argue with the judge when the judge essentially said, I've ruled or I've made my decision. So while they're working together, things seem to kind of disintegrate a bit, but she's not saying anything like, I'm going to leave. She's not saying anything also about hiring a lawyer to sue the judge and the court in Des Moines. But that's what she's doing, and she admitted that. And then as she's dealing with issues with COVID and remote proceedings and things like that, they continue to have disagreements all the way until they have a yelling match. Jennifer Johnson admitted or denied that under oath. She denied no yelling match, but she did. And I think that's really important because A, it goes to her credibility, but B, that's the way she treated our judge. I'm in charge. I'm the admin. I'm going to yell. I'm going to push back. This is my court. This isn't your court. So she leaves Des Moines, giving a week's notice as opposed to what's required, which I think was 30 days. And then shows up with our judge saying, oh, you can't check my reference because there's been a death in the family for my prior judge. And, you know, basically showing herself to be competent and of assistance. And she was like a time bomb. I don't know if any of you have, I know we have a number of judicial members here, but if you've ever worked in a place where people try to undermine you, you know, talk behind your back, belittle you, even do it in front of other people, like one of the clerks did that we heard from Mr. Tyree, that actually was like acting out against the judge while the judge is on the bench and mocking her. And to have the clerks that she relies on trying to undermine her all the time, not doing what she asks them to do. And if you've been in a supervisory position, or of course as a judge, and you ask someone to do something, you expect it to get it done, that they get it done. Not that they push back, or even worse, they don't do it all, but they don't tell you. So you assumed that it got done, but it didn't. How can you, as Judge Flood really wanted to do, pursue justice, have a dream about therapeutic court to make the kind of changes that were important in Bremerton, that she started at 16, going into the Navy, going to law school, getting every award, being on the board of governors, going to law school and raising a family, and then coming to this court to make a change. And you heard Mr. Tyree say that was his dream too. And he thinks the world of her, and they both have that same vision. And he saw all the people and trying to undermine her, and basically hoping against all hope that you throw her off the bench, this commission. And of course, they're watching this. They're probably watching this right now, wanting her to go. So when you look at the change from, at least from as much as we heard about from Judge Doctor to Judge Flood, it was marked different. He had the old way. He'd been there for decades. And sounds like it was, what's the next plea? Do a plea deal. Let's get rid of that jury. Let's get this calendar on the road. Let's just keep going. As if justice is efficiency. But that's not what she wanted. There was this great philosopher in the 60s. He was a longshoreman in San Francisco. His name was Eric Hoffer. And he was brilliant. I think he had a 6th grade education. And he, on the ordeal of change, he has a great analysis of how one of the biggest fears we have is change. And as she came in, she was making some big changes. And people didn't want to do that. And she didn't really have authority to make them do what she needed them to do because they just dissed her. And then they got emboldened really by you, by the commission, because they could just run to Ms. Rasnick, make claims about the judge. So the judge has to walk on eggshells if anybody is. When she's got people whispering behind her back, trying to undermine her and not being part of that good change, but trying to be in kind of the yesteryear of Bremerton Municipal Court. So Jennifer Johnson, we've got people filing lawsuits, 2 lawsuits, I think. And then we've got others talking to lawyers, and maybe 3 or 4 people suing. For what? What are they suing for? Are they saying she was not nice to me? Wait, what is the cause of action? But they've got a financial bias to exaggerate, I could even say to fabricate evidence against the judge. And it's very, very important. The Mr. Hersey, in terms of his impeachment, I thought that was thorough and complete. He doesn't like the judge, but he's part of the old school. Or he can go strike a jury by himself, or he can, you know, do whatever he wants. He's kind of running that court the way he wanted to. And we heard evidence that he's been snippy with her, pushed back with her, and does not treat her with respect. How can you do that as a lawyer? I mean, don't we all take oaths to respect judges and to act in a manner that is professional in court, not push back to judges? Sure, you can argue your case, But you don't show disrespect and push back day after day after day. And that's what she had to deal with. You know, we didn't even hear anything about the witnesses that were of color. I mean, at least acknowledge what they had to say. You know, we had very powerful testimony from individuals that feel like it was a racist type of almost like a hate brigade against this judge. I wanted to go back to let me find this here, Mr. Slaughter Tyree. I mean, if I can just take one moment. It's really kind of heartbreaking because so much good could be done, and hopefully still can be done out of that court. Here we go. I mean, he said that he has a great working relationship with the judge. He said he sits in court, observes her with all kinds of folks. She started the therapeutic court. Community court is what they call it there, of course. And he considers her to be a mentor. And she's made him a better case manager. He's got a lot of experience, and he has nothing but respect for her. He never saw her ever treat anyone with disrespect. He never saw her treat anyone in a demeaning fashion. He never saw her raise her voice or heard her raise her voice. Ever. How could these things be true? How could these two stories be true? How could these folks that are suing the court, that don't want the change, that don't want to work, that demean the judge, that call her Tracy, show her disrespect, push back at her, how can those people be seeing something different than somebody else who doesn't have an axe to grind, that does want to be part of change, that does believe in justice, therapeutic courts, and something new in the system besides incarcerating people and warehousing them? Like, and just put those things one over the other. Who do you believe? I mean, I believe famous Tyra. He did not know the judge before he came to the courthouse. He said that there was no real onboarding when he came on board to do this work. He said that the employees as a group are very against the judge. That same group that sits in the lunchroom and gossips. They're a group. They all get their stories straight. They don't like her. And he also said they pretty much talk about her in there all the time. That he's been in there on court time, on the public time. They were saying things like they couldn't wait till she was kicked out. So they have a motive in terms of slanting their testimony to try and make it sound as egregious as possible. So you'll say, geez, this judge has got to go. But you know what? What they had to say isn't true, and it's not corroborated, and they were all impeached, primarily Jennifer Johnson and Mr. Hersey. There was another employee, Stephen DeRosier, who actually came in a threatening manner back into the court and he got arrested, given this pervasive and spreading quote unquote hatred of Judge Flood. He also testified that these folks are watching the proceedings, and we know that because one of them called it in on the first day, saying that our judge was presiding over a calendar, thumbing her nose at Judge Price and at you, and that was false. Boy, that's something else to come into court or to make an allegation that went into court to try and ruin somebody's career as a judge. Unbelievable. The Will Cohn, who's there every day. He's a security guard that used to be at the SPD for 25 years. And again, he's a person of color. He has great respect for the judge. He's never, ever seen any of the things that the CJC lawyer has been putting forth before you in terms of alleged misconduct or bad demeanor of the judge, ever. It's a small courthouse. And he sits right outside of it. He can hear, he can see. He goes into the courtroom. He's down on the first floor. He's around everybody. How could this be? They have to prove this case by clear, cogent, and convincing evidence. That's, it's a super high standard. It's not as high as beyond a reasonable doubt, but it's significantly higher than preponderance of the evidence. Clear, cogent, and convincing evidence. How can they even do that when we have unbiased witnesses that say their evidence is false? We also had one other witness of color who said the same thing. Oh, my cat just crashed into this. I'm sorry. There. I had no luck doing it at the Fairmont, and I go home to get the Wi-Fi, and I end up with the pets. So excuse me for that. But so armed security. He's been there at the court and did not know the judge before he went to work there. So again, no interest in helping or hindering or anything else. He noticed she has never, in his view, and he had the view and the ability to listen and see, ever treated anybody inappropriately, never treated people with disdain, didn't treat people in any unprofessional way. And that means litigants, that means lawyers, that means court staff, and that means members of the public. She's always professional and courteous. Always professional and courteous. He watches all the different interactions at the court. He's seen her both on Zoom and in court. And he can see into the court from where he's standing on the second floor during court hours, because that's where he's positioned once everyone's admitted in the morning. Of course, they had the issue with that old ex-worker coming in. And then he talked about issues with security, potential weapons, and the like at the court. So where do we go from here in a case like this? These smaller courts, they could be like, there was that great quote in Bonfire of the Vanities, that book, where the prosecutor said all he did every day was just stir the muck, but he was afraid someone was going to take away his stick. I mean, is that what we want? Just judges that come in and say, bring in the next guilty plea. Can't you guys work out a deal? Just next, and just have them go right through and into incarceration, or without help for their mental health, without help for dual diagnoses, without help with housing issues, without help for addictions like meth and the like. Is that what we want? Because I submit to you, that's what the staff that testified against the judge, they didn't want to do the work. And when you really look at what they testified about, they're talking about just demeanor and tone, nothing else. Under Eiler, that's not actionable, that's not sanctionable. I've read you the full quote from that case, but I think it bears repeating part of it here, because I think it's so important. And like I talked about in opening, it's speech and demeanor plus something, because otherwise, you'd be policing every courtroom in the state for different types of judges' personalities. I mean, seriously, how can you discipline somebody for who they are? It's like status crimes. If you're mentally ill, or if you're, you're a certain way, we don't punish people for who they are. We punish people for what they do. Going back to Eiler, we disagree with the commission regarding her alleged violations. Judge Eiler's rude, discourteous, and impatient behavior was certainly unprofessional, but it did not go so far as to undermine the integrity and independence of the judiciary, or demonstrate disrespect for the law, or evidence any failure by Judge Eiler to obey it, or to deny any person legally interested in a proceeding of his or her full right to be heard according to law. And they went on to say she didn't cut deals with litigants behind closed doors, accept bribes, or otherwise demonstrate that her decisions were governed by anything other than the law and the facts of the cases. Her misconduct also did not undercut public perceptions of judicial integrity or impartiality. She showed no favoritism, prejudice, partiality, or bias. The cases that you've had that we're submitting to you, I would like to have request your indulgence to take a look at all of them, because they don't have anything just based on personality where there's a sanction, based on tone where there's a sanction. It has to be plus something else. I also have cases from all over the country that deal with conduct and demeanor, and you don't find discipline of judges for their tone or demeanor anywhere. And that's what this case is alleging. I mean, it's the cooperation. I mean, she could have denied all of this and had a full hearing based upon the Eiler case and the other CJC cases in Washington State. But she didn't do that. She decided to come in and take responsibility. I mean, because clearly on the evidence, we would submit, if we had a full hearing, that she should be acquitted. Let's just she be found to not have violated the code. But she's willing to stipulate to an admonishment and to take a course of training. She's already doing some of that. She wants things to get better, but she's in a horrible position where she's had to deal with people undermining her, not helping her, not in any way assisting in a way that can help her grow and for that community court to grow. And she needs to get past that. Those folks are gone now, I mean, thankfully. And so there's nowhere to go but up. What a lot of talent she has. You know, going in the Navy at 16, going on and getting her undergraduate and law degrees and advanced degrees, winning so many awards for how, what a wonderful contributor to the community and legal community she is. That she was in the first Leadership Institute, that she won the Washington Women Lawyers Vanguard Award, very hard one to get, that she has been on the executive board of the Lauren Miller, which is of course the African American Attorneys Bar Association. Again, huge responsibility, but also a huge honor. She's been one of the most exemplary judges out there. And I could say she's been one of the most exemplary women out there. And I could say she's been one of the most exemplary Black women out there. But she doesn't want me to say those things. She wants to do her job just like any other judge, make a difference, and see that justice is done. Thank you.
Thank you, Ms. Bremner. Now, ladies and gentlemen of the panel, because Ms. Rasnick does have the burden of proof, I do believe she has an opportunity for our limited rebuttal comments and arguments. Ms. Rasnick.
Thank you, Your Honor. I would just start by reminding the panel that whether misconduct occurred is not at issue here. Judge Flood agreed, she stipulated, she signed an agreement that she violated 3 provisions of the Code of Judicial Conduct. That stipulation was accepted. Those violations happened. There doesn't need to be a finding on any of those. So not sure exactly what Respondents Counsel was getting at, but if we're talking about disciplining judges for their acts and not their demeanor or not who they are, there have been acts here, and there has been an agreement that those acts violated the Code of Judicial Conduct. That's the first point I would make. The witness testimony that you heard over the last week demonstrates that there was also a violation of the last charge, the violation of Rule 2.5A. The testimony of the CJC witnesses about the functioning of the court, the turnover, the judge's demeanor towards staff, the effect of the judge's demeanor on staff is unrebutted. There was no one who came forth on the judge's behalf to testify, no, what those former employees testified about that led them to leave this court, their reactions, the fact that they cried at work, the fact that Serena Daigle thought about harming herself. Nobody came forth on the judge's behalf to testify. No, that didn't happen. There was virtually no meeting of that testimony. The judge didn't address it at all herself. Her witnesses didn't address it. There was a lot of discussion by Respondents' Counsel about Mr. Tyra, who is the current therapeutic court coordinator. He testified that he is in the courthouse 1 day a week. And he also testified that he considers the judge a mentor to him, someone who's had a significant impact on his life. Hard to believe that a person who holds the judge in such high regard would testify in any other way but supportively of her, and understandably so. Two of the commission's witnesses who described the impact of her behavior on the staff with the most particularity and most compellingly are Black women, Jennifer Johnson and Trish Kinlow. Hard to know even how to address the allegations about Mr. Hersey. The lengthy audio that we all heard yesterday did not impeach Mr. Hersey's testimony. The judge accused Mr. Hersey wrongly of having canceled a jury, but he did not do that. And the audio proved that. And in any event, the point is not whether Mr. Hersey and the judge have different philosophies about what should happen in therapeutic court. The point here today is that this judge agreed that her actions violated the codes of judicial conduct that regulate her profession, and the job that the panel has to do is to decide the sanction. The factors that I discussed, the Deming factors, that is what the panel has to weigh. Respondents' Counsel did not mention any of them. We have heard about a pattern of misconduct that
Your
is
Honor,
serious and frequent.
I
We've heard
object.
that the misconduct occurred in the courtroom.
Hold on,
That
Ms. Bremner.
I object. It's not proper rebuttal because I didn't address the Deming factors. Now she's describing the Deming factors. Thank you, Your Honor.
All right. Counsel admits she didn't argue the Deming factors. The panel needs to keep the Deming factors in mind. The panel has heard evidence, supports weighing of the Deming factors in favor of the sanction recommended by disciplinary counsel in this case, which is censure with a substantial period of suspension, along with the counseling and training and mentoring requirements under the supervision of the commission that the judge agreed to. The Eiler case did not involve a stipulation to misconduct. The Eiler case was primarily about whether or not there was violation of a certain section of the Code of Judicial Conduct. As I'm sure the panel will note when it reviews that decision, the Supreme Court did not exonerate Judge Eiler. The Supreme Court continued to find a violation and simply reduced the period of suspension, as I am sure the panel will note. Just wanted to correct that for the record. What we've heard this afternoon from Judge Flood and her counsel is just continued deflection, continued blaming of others. Nothing that even looks remotely like acceptance of responsibility or acknowledgement, even after having entered into a stipulation, which suggested that perhaps there had been a last-minute change of heart and an agreement to finally come to grips with what has happened in Bremerton Municipal Court over the last couple of years and to fully engage and commit to making things right and taking responsibility. But that is not what we have heard. If what is happening now in Bremerton Municipal Court is what the judge intended to happen, which is what Respondents' Counsel suggested, then it proves that the judge has completely disregarded her obligation to uphold the integrity of the judiciary and to uphold the public trust. I thank you again for your time. And again, the disciplinary council's recommendation is that the panel find by clear and convincing evidence there has been a violation of Rule 2.5A in addition to the stipulated violations, and that the panel impose a censure with suspension and the conditions that were agreed to in the stipulation. Thank you.
Thank you, Ms. Rasnick. So ladies and gentlemen of the panel, that does conclude the closing arguments of the parties. I do have some closing comments that I need to make. Before I do that, I just want to reiterate what I have said before, which is I have received this morning the declaration of objections and responses that was co-signed by both Mr. Gross and Ms. Rasnick. I have not ruled on those yet. I will rule on those, and you'll be notified of the rulings on those. I want to assure you that the version of the declarations that the panel will use for their considerations will be consistent with those rulings, and will not deliberate with versions that are inconsistent. Let me just make some comments here before we say goodbye for the evening, at least with respect to the public portion of these proceedings. Under the commission's rules, all deliberations of the panel in reaching a decision shall be confidential, and the members may not discuss the case with anyone outside the panel. Any finding of a violation of the rules of the Code of Judicial Conduct shall be based upon clear, cogent, and convincing evidence. When the deliberations are complete, under Commission Rule CJCRP 24D, the panel will file a written decision or decisions in an open session of the commission. The deadline for filing of a decision is within 90 days of the evidentiary hearing or a filing of the transcript, unless the presiding officer extends the time. If personal attendance is required, the judge will have at least 14 days notice of the announcement. The commission's panel's decision is final 14 days after the judge has publicly received it, unless a motion for reconsideration is timely filed as set forth in CJCRP 24E. If a decision of the commission is adverse to the judge has a right of appeal de novo to the state Supreme Court. If the decision is to recommend to the state Supreme Court that the judge be removed, then the judge shall be suspended with salary from her judicial position effective upon filing with the Supreme Court. And the suspension remains in effect until the final determination is made by the Supreme Court. The rules also provide under subsection B7 that disciplinary counsel and respondent may submit their respective proposed findings, conclusions, and recommendations for discipline. We have not requested that of either counsel, and I'll discuss further with the panel as to whether or not they request that. It is not necessary at this point for either party to submit proposed findings, conclusions, or recommendations, but I just want to alert you that that possibility could occur. So with that, I want to thank both counsel for your thoughtful presentations. I want to thank Judge Flood for your participation. I want to give a shout out to our court reporter, who I've regularly called, announced my admiration for. Again, I've had many court reporters, and I have never been in a multi-day hearing where I have not heard at least one complaint. And so thank you so much for your work here today. At this point, we are going to adjourn from the public portion of this hearing, unless there's some urgent matter that any counsel wants to raise. Ms. Bremner?
No, Your Honor, just we're filing that list of this Washington CJC cases that I mentioned.
Ms. Rasnick, anything from you?
Nothing, Your Honor. Thank you.
Okay, so I'm going to ask the panel members to be placed into a breakout room in which we can have a brief discussion. But again, I want to thank the parties for their participation. I want to thank the staff for their hard work during these hearings. And with that, we are adjourned.
Thank you.